The same being a mandatory condition under section 328, 329 CRPC, the failure to take a decision on the capability of the appellant to defend himself has caused prejudice to the appellant, and in our view has occasioned a failure of justice. Is this a thing? It's a right thing. Oh, right. Next, consequently, the impugned judgment is set aside. As the finding of the medical board is to the effect that the appellant suffers from chronic so and so, the respondents are directed to release the appellant from jail and produce the appellant before the Mental Health Review Board, constituted under Chapter 11 of the 2017 Act, who shall then examine the appellant and take a decision with regard to the future course of action to be taken in respect of the appellant in terms of the 2017. The field is accordingly disposed.
Badly. Already item number 15, hearing method.
Yes.
Here, my lord, I will argue on behalf of ML also. The paper book supplied to me, there are some pages are missing. So I cannot, my lord.
Which pages are missing? Page numbers?
Already, I have noted, my lord, which is here. My lord,
Please tell us.
Yes.
If you have noted.
I will take xeroscopy. I will take. Good matter may direct allow me to take xeroscopy of it.
Okay,
And
Mr.
matter may be, my lord, take after my lord, Bihu.
Okay, Mr.
AIUD on behalf of ML also.
AIUddin, on behalf of Mr. M.A. Laskar, submits that some pages of the paper book are missing. He accordingly prays that he may be allowed to obtain photocopies of the missing pages of the paper book from the court record. He accordingly prays for adjournment. The prayer is allowed. As the same is not objected to by Ms. B. Buyan, learned APP, lays the matter after the Bihu vacation. Yes, 15 and 16 naturally. Yes.
Can it be, my lord, on 9?
9 is not that is Bihu before Bihu.
Then on 23rd month.
You make up your mind. What do you when do you want?
23rd.
23rd.
I am available.
Document text mention item number 17 of hearing, last item.
17, yes.
My lord, today I'm unwell, my lord.
Why?
Due to the unrelated.
Because they are eyewitnesses to the crime.
Yes, that is there, my
That is why you are unwell.
no, my lord. After vacation, anything.
It's a clear-cut case. They are eyewitnesses to the crime.
That is there, my lord.
Then
That is-
what is there to
There, my
argue?
lord, some preparation is required, but
What preparation? You're going to say the eyewitnesses are not eyewitnesses.
eyewitnesses, but on that we'll submit.
Okay, right. On the prayer for adjournment made by Mr. J.M.A. Chowdhury, Learned Counsel for the appellant, list the matter
On 9th,
on 9.
I'm
Okay, give a date.
my lord. My lord, on 19, my lord.
19.
Afternoon.
No, you provide, but you make him pay. Let him pay for it. Okay, right. In that item, you just say let the registry provide the missing pages to the council for the appellant. Missing pages of the paper book. Yes.
My lord, this is an appeal against the impugned judgment dated 29, 2023.
Court of the Additional Section Judge bracket FTC Barpeta Assam, by which the appellant have been convicted under section 120B/385/323/354/302 IP. Admit the appeal. Call for the LCR. Ms. B. Buyan appears on behalf of the state. And learned APP appears on behalf of the state. List the matter of proposal.
There is an IA, right?
In the IA, right, Ms. B. Buyan and learned APP is granted 4 weeks time to file written objection to the application under section 389. Yes, yeah.
Lordship, one connected appeal is also pending. I'll provide a number.
Okay, in the main appeal, you write, as Ms. Buyan, B. Buyan, learned APP submits that an analogous appeal, comma, that is criminal appeal number dash is pending before this court, comma. Liz attack this matter along with criminal appeal number dash. Give us the number.
My direct appeal in that matter.
Give us the number.
Yes.
So maybe the records are there in that case already,
Already paid.
in that case.
Do you have the number? Provide it. What do you like?
I will.
421 now? 23. Huh?
After 4 weeks,
Ah, 4 weeks. Good.
Statutory appeal.
Huh?
Statutory appeal, the appellant convicted.
Heard Mr.
Ayush.
Ayu Chaudhary, learned counsel for the appellant who submits. No, first off, this is an appeal against the judgment dated
7/12/20.
Huh?
7/12/2020.
7/12/22.
23 Lord.
23 passed by the court of the additional session judge Birasi Para Dubri in sessions case number 74/2015, by which the appellants have been convicted under section 147/148/323/302/149 IPC. Amid the appeal, call for the LCR. Ms. B. Boyan appears on behalf of the state. Leaves the matter after 4 weeks. Then, that's all.
Okay.
My lord, as per this order dated, my lord, 14/11. We approached the CGM court, my lord, where the notice was sent for. Last date was on 16th, my lord. The police has given the report that address is not found.
14/12. You see, it says, a letter from additional district session judge Bilasi Para Dubri has been received stating that LCR has already been sent to this registry in connection with criminal appeal 306/2023.
306, my lord.
Yes, so there
306
must be another
Yes.
analogous appeal.
Total
306.
Same officer I found in another matter also to this matter.
So there is another appeal besides this.
Total 6 appeals out of 10 judges,
So,
including present 2.
so. Now, with regard to the 309, what to do? You give us you take up the 309.
LCR, my lord, in that case,
LCR, what is that? We can look at the judgment itself.
Yes.
Look at the judgment. Give me the, I know, this is my- I 606 6614. 60661. Give me 616.
Mine is 2541.
Your name?
Mine is 254.
254.
Item number 7.
Two five four, yeah, item 7, okay. So your Lal Cham Ali,
By the total 10 in this case, by all out in the judgment, I am for 3 here and item number 8 also 3. 3%. Just a short note, my representative. Okay. Occurrence 1999, my. The loss value FIR also, my lord. What happened, my lord? Occurrence is, my lord, 21/6/1999.
occurrences
21/6/99 at 4:30 p.m. '99. Then FIR is made after 2 days, 23/6/99.
FIR on
On 23/6/99. 23/6. The loss you got it. And your lossable fine and commencement from your lossable fine, the evidence it started from here. Your lossable fine is page 15, my lord, in my mistake. Charge was framed on 18/3/23. Started. In fact, I think your local is the dates, right? After about 12 years, my lord, charge was framed. Then evidence, my lord, it commenced on 25/9/13. And judgment is 28/6/20. From the FIR, my lord, informant, he is.
you were in bail earlier.
Yes, it's all on open, all of. What happened in this case, my lord? In fact, there was a, my lord, one riot took place between Santhal and this type of people. Riot took place in that particular area. So many people died. And this here what we find, my lord, maybe because dead body was recovered subsequent to dead body. One was found headless, put up identified. One was identified and it was recovered, my lord, after on 26. Postmortem was done on 26, my lord, recovered on 25. And this in the FIR I have given constated copy of lossable fine. In the FIR, person has stated his name on Assemblage PW2 mile.
Yes, but where is the evidence against you?
My against point of Peter 5, 6, 5, 6, and 11 and 50. But those persons are not there, my lord. My only question, my lord, those persons 5 and 6, they were in jail in connection with that case. from jail, they have been brought to the court file. And the same, my lord, same statement, the same contention, same deposition, both 5 and 6 people. And it is admittedly they were in connection with a case, in a murder case, where my lord, one of the father of one of the accused, my lord, was killed by those informant parties. And they were in the jail, 5 and 6, they brought from the jail and they came and deposed against all the people. In fact, my lord, as per FIR informant, neither he was present and except one Hasim Ali, none was present by. Hasim Ali is PW2, your work and is PW. He is not supporting the case. I am just reading my PW1, informant. Informant himself is saying, my lord, that the place of occurrence was a died area. I was not present during the incident at home as such. I have heard about the incident from other people.
No, where is your name mentioned by W5 and PW5 and 6?
Yes, 5 and 6, my lord, your lordship will find. My lord, this is the position I am having.
Huh?
The position I am having, my lord.
Or deposition is not here.
Not here, but the LCR not.
Let the matter be taken up with the LCM.
I was just looking at the judgment. Their names are not reflected here.
But, what, the application filed by us, my lord. PW5 seems to be the eyewitness, my, the opponent.
That is what I'm saying.
He stated that after
But
hearing.
you
the
should have
trial-
put it here.
That is what I'm saying. 5 and 6 were in jail. From jail, they have been brought.
But then for us to take a decision, we don't have a copy of your deposition.
But we will let after 2 days. Yes, he is also item number 8.
Well, I have been. I have a copy, madam. Just PW5 pilot. He has for the first time implicated all the person. Lordship kindly see his deposition and the IO's deposition only. That will suffice for us. No 5%. I got the deposition. This is a deposition. Lordship kindly page number PW 5, my lord.
Can you give a copy to her also?
The copy. PW5. Execution wholly reliant on PW5 pilot. Mary. I know the complainant and the accused person. I know the deceased person, Jahar Ali, Shahar Ali. Incident occurred on 22 ago. The incident occurred in the evening of 22 village. 22 accused Makbul is one of the accused person in the case. My house is situated near the house of the accused Makbul. About 4 o'clock, I heard the hue and cry coming from the house of accused Makbul. After coming out from the house, I saw Jahar Ali was running towards my house and he was followed by 8-9 persons.
Just a minute. Who are you? You are
I am my lord,
Sajid Ali and
Shahid Ali.
so many. People and Zamal Ali.
Yes.
And what about Lal Chan Ali, Wahab Ali, Abdul.
Basically, he has taken all the names in the sheet. There's no dispute at all. The Syed Ali Habir, well, regarding the Syed Ali's name, there's a dispute, but at this stage, I'm not going into that. The Syed Ali, Habi Jamal, Hassan Ali, Chand, Wahab, and Suleiman. When Jahar Ali reached in the front of house, the accused person who followed Jahar Ali got hold of him. After catching Jahar Ali, accused Syed Ali had struck him with a ramdao. Another accused Habi had struck Jahar by a long knife. Both the accused person has hit the victim on his head, as a result of which the victim fell down on the ground. The other accused person, Hassan Ali, Jamal Ali, Suleiman Ali, etc., had assaulted and hit the victim by the sharp weapon, as a result of which the assault of the hitting the sharp weapon, the victim Jahar Ali breathed his last. He died on the spot. I saw the pistol in which it carried by the Syed Ali. The pistol was tied by a towel which was wearing by accused Syed Ali. Accused Syed Ali turned the towel into two pieces and he tied the hands and legs of the deceased by the pieces of the towel. The accused Syed Ali told the another person also killed by them, namely Chahar Ali. Both the dead bodies were taken towards the river Champa. I saw the accused person taking the dead body Jahar Ali towards river Champa. I saw the killing of the deceased Jahar Ali, but I did not see the killing of the deceased Chahar Ali. I have heard from the accused person that they had also killed Chahar Ali. Thereafter, the accused person left toward the Champa River. Police asked the incident. I recorded my statement across. Today, I have come to depose before the court from the Dhubri jail, as I am languishing in the murder case of the Hassan president. I, along with the four others, namely the Jahiruddin, Gulbar, Abdul, Batin, Abu Shama, were acquitted by the trial court. However, the High Court has convicted us and we are languishing in the Dhubri jail. And from Dhubri jail, we have appeal in the Supreme Court. Accused Syed Ali, he is the accused, one of the appellants. He is the brother of the Hassan president. Accused Maqbul is the uncle of the Hassan president.
What do you mean by Hassan president?
The person who they have killed.
Hassan president.
Yes. So they were in the languishing jail in connection with the killing of the Hassan.
Nothing to do with this incident.
Nothing to do, but we are related to the Hassan president. So that's the maybe the reason for implicating us. That's the one of our defense matter. This accused Jamal SK is a cousin brother of the Hassan president. It is not a fact that the accused Izzat Ali is a cousin. Now, Lordship, kindly turn to the now last few lines, my lord, last 4 lines. It is not a fact that I did not state before the police that I saw the accused person running behind the deceased and they caught hold of the deceased and thereafter killed them. That was the suggestion specific to this PW5. Last 4 lines, my lord, from the bottom. I did not, it is not a fact that I did not state before the police that 7-8 people were running towards my house and they were Syed Ali, Lal Chand, Wahab Ali, Habi, Suleiman, etc. It is another fact that I did not state before the police that the accused person caught hold of the victim Jahar Ali and killed him by the sharp weapon. It is not a fact that I did not state before the police that accused Syed Ali had first assaulted the victim by Becky down. Now, Lordship, kindly turn to page 31, my lord. Page 31, I own. Page 32 is the relevant portion, my lord. PW5, Rahim did not state before me that he saw the accused person running behind the deceased and then caught hold of the deceased and thereafter killed him. He did not state before me that the accused Syed Ali assaulted the deceased with Becky Dao, short cutting weapon. He did not mention the Hassan Ali, Suleiman Ali directed the other accused to kill the deceased. So this is for the first time he has implicated all the accused person in the court. There is a contradiction with his 161 statement. That has been proved. And apart from my lord, our defense is that he is the person who has killed our relative Hassan President Mara. So accordingly, he was convicted and that is maybe the another reason for implicating him. And for the first time, he has implicated And in PW4, while PW1 minor, while filing the FIR, he has categorically stated that he was informed by the three person who was the eyewitness. But these PW5, he does not fall in that category that he also was eyewitness to the offense. So that's my
What about 6?
6 also the same. With 5 and 6, he is also convicted for the same Hassan Ali case. He is also coming out from the jail, has deposed for the first time. So basically that is all.
Depose against you.
Deposed again. All
But
of them.
IO does not say anything about,
IO is silent about regarding PwC.
you did not question.
We did not question. IO is silent, we question, but the IO is silent. That's fine. PW 9 Lordship kindly see once again. Just a moment, brother. 5 and 6 happens to be with 9 man. He is 19, my Lordship kindly see. That's very important.
PW 9.
PW 9, because as per him, this PW 5 and 6 were together along with 9. But you kindly see the cross part page 19. This Sameer Ali, on the day of occurrence of the incident, I along with the Jaharuddin, that is the PW 6, my lord, Jaharuddin, then Rahimuddin, PW 5, and Abdul Jalil came to Chapar Market. Chapar Market is somewhere else. We got to know about the killing of the Jahar Ali and the Sahar Ali by some assailants, and accordingly we came together to the place of occurrence. We came to know about the incident killing of the deceased person in the evening. We came to place of occurrence after 2 hours, but we did not find the deceased person at the place of occurrence. I later on heard some assailant from the Chaur area had killed the deceased person. Similarly, other witnesses corroborated the same thing, that there is a dispute between the two groups, and because of that, now PW2 was not declared hostile, my lord. He was with him, but he was not declared hostile as per FIR, but he was not declared hostile, and he is part. So there's no corroboration to that fact, my lord, as he was not cross-examined by the prosecution. So as per PW1, my lord, Hussain Ali, Zahiruddin and Rahimuddin. Lordship, kindly see the page 4 of PW2, my lord. Actually, nobody has identified, my lord, as per him. The distance from the so-and-so village, about so-and-so, to reach to so-and-so village, I came to the Kashmir to cook by the engine-fitted boat. When we landed at the so-and-so engine-fitted boat, then myself and the deceased person went to their destination on a different road on foot. I came to my village by the different road and the Sahar Ali and the Jahar Ali went through the different road. Later on, after 2 hours, I came to know that some unidentified person had killed Sahar Ali and Jahar Ali. At the relevant time, the incident, there was a riot between the Santal and the Boros, and for the said riot, several bodies were found dead near the Champa River. After the incident, I did not meet the complainant, Mahar Ali. After 2-3 days, the dead body was recovered, which was not identified by the police. Later on, many people said that the dead body maybe belonged to either Boro or Santal. Nobody had identified the dead body of the Sahar Ali and the Jahar Ali. There are cases instituted against the deceased Sahar Ali and the Jahar Ali. This is Jahar Ali and the Sahar Ali were having enmity of lots of people of our village. About 10-12 days from the date of our incident, police took me to the magistrate for recording my statement to incident. Now, he is this. Now, PW6 is a very important. While he saw the entire incident probably from the boat itself. And whereas these diseases were going through the road and he was coming through a boat from the market, he saw the entire incident. It's quite unbelievable, my lord. And he has not informed there a boat. There are 50 to 60 people he has admitted. Not to kindly see the PW6, the another eyewitness, cross part, page 13. Today, I have come before the court from Dhubri jail. I am languishing in the jail for the murder of one Hassan President. Accused Syed Ali is the brother of the Hassan President. Accused Maqbul is the uncle of the Hassan President. Accused Habi is uncle of the Hassan President. The other accused person are not relative of the Hassan President. The incident occurred on a Monday. I was returning from the market by river road in a boat. This is very important. He was returning from market to a river road through a boat. In that boat, there were 40 to 50 people. I did not know the names of the other passengers of the boat. It is not a fact that I have heard about the alleged incident in the market. Thereafter, I came to the place of occurrence along with the Abdul Jalil and Abdul Rahman. My house is surrounded by the houses Spencer, Rahman Ali, Abdul Rahman, Samajuddin, etc. I did not tell my neighbors about the incident. So immediately after the incident, he has not informed anybody, neither to his neighbors, and he was coming to the boat when he saw the entire incident. And the other PW9 denied his presence, my lord, PW6. So if the PW5 and 6 goes, my lord, there is no case at all against them. I have shown to your lordship that he is implicated us for the first time. And he is already hostile to us because of his conviction. And it sticks. There is a doubt regarding the presence of 6 at the place of occurrence as far as the PW9 is concerned. And his own statement that he was coming through boat along with the 40-50 passengers. He did not inform anybody immediately after the incident. So that's the case. I'll leave it to your lordship. I think this is a fit case to grant pilot phase.
Or about 15, page 35.
Okay. Son, my lord. Son of the deceased. He was not the, my lord. The dead body was, as per his cross, my lord. It was recovered after 2 days of the incident, my lord.
So when we reached the house of Maqbul, line number
Case 15, my lord.
35.
Yes, sir. PW 15, my lord.
Yes.
Yes.
The 6th line.
Yes, my lord.
When we reach house of
From where we proceed towards the house, when we reach house of Maqbul, accused Syed Ali commanded to hold us. Hearing this, we ran after the crossing the Chandipara, accused Jamal, given a blow to Sahar with Keta. instrument used for the catching the fish. Borali, Sahar fell down. Accused Siraj gave a dagger blow on his throat. Seeing the Jahar Ali run away, I too ran away out of fear from the place of occurrence. After coming to safe, Hassan Ali court of the Jahar and the Hassan Ali called the other accused person who has all assaulted Jahar Ali and other accused person also before the court between 2020. After reaching my home, I disclosed the incident by my younger brother, Sabar Ali, and my neighbor, Surman Ali, Ashraf Ali, and again proceeded to the place of occurrence. That is not supported by the informed big part. And Lordship now kindly see the cross part, page 36. The incident took place about 19 years back. At the time, I was 18, 19 years old. I lived in the Kachimari at the time of incident. I was resided in the Swenso place of Vaipuri PS Swenso. I cannot say whether any murder case was pending at the court of Bongaigaon against Jahar and Sahar with their other person. I made the statement before the police during investigation. Dead body of Jahar was recovered after 2 days of the incident at the river Champa, and after 3 days of the incident, dead body of Sahar was recovered at Sildanga Bill. The dead body of Jahar was recovered without head. However, full dead body of Sahar was recovered. I got it. It is not a fact that dead body was recovered. Sildanga Bill and river Champa was not identified with dead body of Sahar and Jahar, and those were dead bodies of the Santal Adivasi people. It is not the fact that the Sahar and Jahar was absconding to save them from the murder trial. It is not the fact that I did not make a statement before the police. On the date of incident, I went to the Chapar market along with the Sapur, Abu Ansar and Hassanam. It is not the fact that I did not make a statement before the police. On the date of incident, at the time of returning the Chapar market, we boarded machine boat and reached Chandipara Ghat. From that, we have proceeded towards our house. When we reached house at Makbul, accused Syed Ali commanded to hold us. Hearing we ran, and after crossing the Chandipara, accused Jamal gave a blow to Sahar with a keta centro. Sahar fell down and accused Siraj gave a dagger blow to his throat. Seeing the Jahar Ali ran away, I also ran away out of the fear from the place of occurrence. After coming few steps, Hassan Ali caught Jahar Ali, and Hassan Ali also called accused of had assaulted Sahar Ali. An accused person present before the court beaten Jahar Ali. Seeing all the incident out of fear, I ran to save my life. After reaching my home village, I disclosed the incident to my younger brother, Sabar Ali, and my neighbor, Surman Ali, Ashraf Ali, and again proceeded to the place of occurrence to the Sabar, Surman, and Ashraf, but did not find the dead bodies of Jahar and Sahar. I had given my thumb impression in the police station. I had seen dead bodies of Jahar and Sahar at the place police station. Dead bodies were taken to the police station. Now PW 17, Lordship. He said that he signed in this teaser list, but his signature is not there. Anyway, my lord.
Yes, anything else?
No.
Mr. Chaudhary, anything? Same thing.
Who is the main man? He was along with the informer. Informant said, I along with PW2 are coming together. His statement paper 3 of October said he did not support the case. He did not support the case. PW2 man.
PW did not support the case of the prosecution.
PW2.
Did not support
Did not
case
support
of.
it. And the informant specific case is that he along with PW2 was coming. And basically the matter PW 9 matter. 9 also your lordship has just seen. 9 is saying that my lord is PW 5 and 6.
PW1 is the informant.
They inform. And in fact, I have given the FIR also, your lordship.
So the entire case rests on 5, 6.
Yeah.
9,
5, 6,
9 and 15.
9, 11, sorry, 15. 11 is my son of PW 7. Or
Son of
PW 6. So they are on the stereotype mind of they are the son of PW 6 mind. Zahiruddin.
And 15 is son of deceased.
Son of the this is Shahar Ali.
Tahir Ali.
Shahar Ali. So they have next model they are there. So this is PW 9. Again, you have kind of PW 9. They are very short kind of PW. Yes, madam.
Lordship, may I reiterate my submission, later records with for your lordship along with the, because some of the evidences are in Varnacular. They haven't been translated, whatever has been provided by Dalit. Senior friend,
They are the
lordship, I may be wrong, but hurriedly I have gone into the records. Lordship, relevant witnesses 8, 11, 12 and 15, your lordship. 8, 11, 12 and 15. From the records, there might be a lot, hurriedly I have gone into, but materials are against them.
8 yellow, can you see 8 man?
He was a gentleman, what to do?
Because records are not.
Initially, my role.
I know, but then this thing is here.
Lordship, but your lordship may kindly have a look, again,
Uh,
the evidence part, 8, 11, 12 and 13.
8.
8 yellow, can you see?
Yes.
Wife of one of the deceased. Very well. He did not see.
PW5. Fifth line, I heard hue and cry. Coming,
Who are you? Whose
PW5
evidence are you
my lord.
reading? PW5.
yes,
No. So
next line.
no. What do you want to? What do you want to?
They
I've read it.
witnessed the occurrence. They witnessed the occurrence in the cross-examination also.
Oh, so it's you see, you make a submission, we will decide.
So lordship, what,
Oh.
because first of all, records are not with your lordship, the set provided by my learned friend. Some of the evidences are in vernacular,
Okay,
lordship.
is it?
Yes, your lordship, from
That
evidence.
is not the
No,
event
the
are all
evidence
English.
cannot be relevant. The face of it, we cannot say
Yeah.
it's not relevant, my lord.
All are English model, those relevant again.
Now, why did we hear?
PW2,
Why did we hear why did we waste so much time then? Anyway, if some of the evidence are in vernacular, then I think we'll have to adjust that.
evidence of BW1 also, maybe it goes in their favor, but it's in vernacular. And some are handwritten, PW20, my lord, doctor's evidence.
Okay, we'll adjourn the matter. She's not ready.
We are ready, my lord.
You are ready. We are ready also. But she's not ready.
See your cross-examination part, page 27, it's in vernacular. PW 13, page 29 is in vernacular, page 28, 29 vernacular, you know.
This is there.
Okay, we'll adjourn the matter. Right,
Date,
huh?
your lordship says, the record,
Yeah, it's just right in the main appeal. In the main appeal, you're right. As per office note dated 14/12/2023. Recorded in criminal appeal 254/2023. LCR has been sent to this registry in connection with criminal appeal 306/2023. Mr. H.R.A. Chowdhury, learned senior counsel, submit that altogether there are 6 appeals,
Six appeal
6 appeals pending in this court
against the same judgment.
against the impugned judgment.
Appeal judgment.
It's up- Besides the present 2 appeals, the other cases are criminal appeal number
Number 286,
286 of
23,
23,
288, 23,
288, 23,
295, 23,
295, 23,
306, 23.
and 306, 23. So, sir, in view of the above, comma, tag these cases along with 286, 288, 295, 306. Has paper book been made in any of those?
Paper would take time out of the face of it, it is a case for date matter. One day my, if necessary matter will give translated for it. Will give.
Is this matter after the vacation?
Date when it.
Give a date.
Tender is to be directed to translate the.
Yes, that was.
Stop,
In the meantime.
the registry to prepare the paper book. In the meantime. Give a date.
Can no get away.
Huh?
Maya.
We are handicap. Calendar.
Oh, yeah, I have.
Calendar.
Asset.
Was small, I cannot give all the language.
You need a
But she
magnifying
given
glass.
to me, this is my, this piece.
Down.
What happened? January, my lord. Let it be on 11, my lord, after
11.
11 January. Allah is- Allah is-
Here in this case, your lordship wanted to see some judgments on mental assessment and physical assessment of juvenile. So this is new amendment, lordship, I could not find much judgment.
But out here, the punishment that can be given by the board is maximum is 3 years.
Probably this 2023 5 SSC 522 lordship issues a
So basically, he's a juvenile.
juvenile.
Only thing is basically whether the conviction will stand or not.
Yes.
As per the conflicting decisions, one says will not stand, one says will stand. So, supposing we go by the latter, okay, it stands. Now, even if we send it to the board, then the board will have to give the sentence. Correct? And if it gives the sentence, how many years has he been in jail?
That is more than 3.
More than 3 years. So at the end of the day, nothing can come out of it. Correct? Then what to do?
Probably this judgment constituted by
please.
judgment. Yes. Yes. 504 Garden, alias Patia by the state of it.
Which para?
There I'll be relying on 19, 20, 22, 23, 26, 35, 36, 37 and 38.
Basically 19 onward.
Lordship.
But which is the most relevant para?
Lordship, may I read para 19? We may note here at the outset that the appellant for.
Have you got a copy?
Have given the.
No, for your colleague. No love lost between colleagues.
No. I can provide I don't have extra.
Let her read.
I'll read it slowly.
Uh-huh.
We may note here at the outset that the appellant for the present has chosen not to challenge the conviction, but is only claiming juvenility and consequently the benefit of sentence provided under the 2015 Act, reserving his right to address on conviction and sentence if he fails on the preliminary issue of juvenility. There are a series of judgments on the state issue. Some have set aside the conviction, sentence, and have terminated the proceedings. Others have upheld the conviction, but on the basis of sentence already undergone, in more than the maximum permissible under the Juvenile Justice Care and Protection Children Act 2000, have directed for release of the accused and hurt, where after maintaining the conviction, this court has referred the matter to the JJB for passing appropriate orders on sentence. All the judgments delivered earlier, which are briefly discussed herein under, relate to the 2000 Act. Present case falls under 2015 Act as the offence itself is of the year 2017. Then para 22,
Para?
para 22, Your Lordship.
Yeah.
Para 20, Your Lordship.
Yes, yes, read everything.
In Jitendra 21, in Jitendra Singh versus State of UP, a two-judge bench of this court confirmed the conviction. But as the appellant therein could only be awarded imposition of fine, the existing fine of rupees 100 was found to be grossly inadequate, and accordingly, the matter was remitted to the JJB for determining the appropriate quantum of fine that should be levied on the appellant and the compensation that should be awarded to the family of the victim. Madan B. Lokurji, the first author of the judgment, dealt with the issue as to whether the conviction could be sustained by this court or it was only the sentence, which was to be dealt with in accordance with the 2000 Act. Almost all the previous judgments were referred to in para so-and-so of the report with respect to all the four categories of the cases wherein different views have been taken by this court. The first category was where conviction was upheld but sentence quashed. The second category was where conviction was upheld but sentence was modified to the period already undergone. The third category was where conviction and sentence both were set aside, and fourth category was where the conviction was upheld and the matter referred to JJB for awarding a suitable sentence. In para 21 of the report, Lakurji sums up the four categories. Further, in para 29, reference is made to section 20 of the 2000 Act, and it was finally concluded in para 30 that the matter needs to be examined on merits, and if the juvenile is found guilty of the offense, he could not be allowed to go unpunished. But considering the provision of 2000 Act, the question of sentence must be left to the JJB. Para 23, my lord. It would be proper to reproduce para 28, 29, 30 of the report of Lakurji that has been referred, your lordship. Then para 26, my lord. Similar view was taken by two judge bench of this court in Mahesh versus State of Rajasthan, wherein this court confirmed the conviction. However, the sentence imposed was modified to the period undergone. Therefore, this judgment relies upon the law laid down in Jitendra. After framing the issue as to whether the validity correctness of the conviction recorded by the trial court could be maintained, this court proceeded to give due consideration in para 4, 5, and 6 of the judgment. Therefore, thereafter the bench proceeded to consider merits of the conviction after the same in para 7. Then, your lordship, para 35. The intention of the legislature was to give benefit to a person who is declared to be a child on the date of the offense only with respect to his sentence part. If the
Wait,
conviction,
para
para
20,
35,
wait, go to para 28,
para 25.
28.
Lordship. In Saturday versus State of UP, following the racial and legal proposition laid down Jitendra Singh, this court upheld the conviction and after setting aside the sentence of life imprisonment awarded to the appellant, it was directed that the jail authorities would produce the appellant before the JJB within 7 days. And thereafter, the JJB would pass appropriate orders regarding the detention and custody with respect to the appellant hearing. May I take your lordship to para 35 now?
Yes, no, go to para 29. Please carry
We
on.
may also refer to the judgment of this court in Raju versus State of Haryana, wherein Mohan M. Shantanagodar Gowra, J, speaking for himself, N.B. Ramanna J, as he then was, and Indira Banerjee J, set aside the conviction and sentence of the appellant therein, and as the appellant therein had already undergone almost 6 years incarceration, but had been released on bail, the bail bonds were discharged and all proceedings against the appellant were declared to have been terminated. In Raju case, the appellant had not taken the plea of juvenility before the trial court. However, such plea was raised before the High Court, but the same was rejected. However, this court got an inquiry conducted by the registrar of this court, who found to him to be aged less than 18 years. The judgment in this case mainly dealt with the issue as to whether the report of registrar of this court could be accepted over and above the finding of the High Court, which is different. The judgment proceeds to deal with this issue and ultimately comes to the conclusion that this could be done provided this court itself places the correctness of the report or registrar judicial. This only in Penultimate para 27, while allowing the appeal, it granted the relief of setting aside the conviction sentence and further terminated the entire proceeding. There is no prior discussion on the issue whether conviction was required to be set aside or not on this technical ground. Merits of the conviction were not gone into. No ratio is laid down in the said case on this issue. Only while granting relief, conviction has also been set aside. Following the above judgment in Raju, two judge banks of this court in Ashok Kumar Mehra versus State of Punjab set aside the judgment of conviction and sentence awarded to appellant 2, wherein who had claimed to be a juvenile. Para 14 of the said judgment, which grants the relief, is reproduced hereinafter. In view of the foregoing discussion, we are of the considered opinion that since appellant 2 was a juvenile on the date of commission of the offence, and though till date he has already undergone considerable jail sentence, partly as an under trial and partly as a convict, yet the appeal filed by the appellant 2 has to be allowed, as was done in Raju, without going into the merits of the case and passing any other consequential order in that regard. It will be pertinent to mention that in this judgment also there is no discussion with regard to the issue as to whether the conviction should be set aside. The judgment also does not lay down any ratio that if the respect of juvenile trial has been conducted by Sessions Court without the accused having claimed juvenility before it, conviction could be set aside as being vitiated in law if subsequently it is held that the accused was a juvenile. The above judgments relate to an offence covered by either the Juvenile Justice Act or the 2000 Act. We now proceed to briefly discuss the provisions under the 2015 Act. Section 9 of the 2015 Act is clearly reproduced in the earlier part of the judgment. According to subsection 3 of Section 9 of 2015 Act, the court which finds that the person who committed the offence to the child on the date of commission of such offence would forward the child to the JZB for passing appropriate orders and sentence, if any, passed by the court, shall be deemed to have no effect. This does not specifically or even impliedly provide that a conviction recorded by any court with respect to a person who has subsequently, after the disposal of the case, been found to be a juvenile or child would also lose its effect. Rather, it is only the sentence, if any passed by the court, would be deemed to have no effect. There's another reason why a trial conducted and conviction recorded by the Sessions Court could not be held to be vitiated in law, even though subsequently the person tried as has been held to be a child. The intention of the legislature was to give benefit to a person who is declared to be a child on the date of the offense only with respect to its sentence part. If the conviction was also to be made ineffective, then either the jurisdiction of regular Sessions Court would have been completely excluded not only under Section 9 of the 2015 Act, but also under Section 27.
That your judgment has been followed. That case, your judgment has
My
been
lord,
followed. So, we will cut a long story short.
my lord.
If you're challenging the conviction, then we have got to do the entire year. But if you're not challenging the conviction,
I'm not challenging the conviction.
you're not challenging the conviction, then we can decide on the basis of conviction remains sentence to be awarded as per the 2015 Act by the board.
Board.
And what is the maximum punishment that can be given? 3 years.
Let
Under
the
which
board,
section?
lordship, let the board decide upon.
Let the board decide. But we'll have to also mention, no, that this is the maximum. Supposing they give more than the maximum. Where is the maximum given?
That's section 80.
Give us section 80. Yes, the 2015 Act. Juvenile Justice Act, is it there? Ah.
Section 18, clause C, small c.
Did not come, lordship, the other day also make the submission. Direct the child, lordship,
18, just a
18G?
minute, just a minute,
Fine.
madam. Just a minute. Yes.
direct the child to be
Just a
sent. Okay.
Yes,
18G, direct the child to be sent to a special home for such period not exceeding 3 years.
where are you reading?
18G, my lord.
18G.
G.
Ah.
So it's regarding special home. wherein we can keep.
You cannot put him in jail.
Yes,
You
that's.
cannot put him in
yes.
hard.
For providing informative services including education, services.
Okay, we can send him to the board.
Yes.
Let the board take a decision.
It is agreed with the proper.
Any problem?
No, I was in the terms of interim, I have a reduced in terms of section 12 of
Correct. Section 12.
because of the section 9, subclause 3 says, if he is found to be juvenile, then sentence awarded to him will have no seem to be have no.
Huh?
Section 9, subclause 3, Latina and it.
Section 9(3). This will be prior to the trial,
No, but
prior to finding.
because of the, your logic knows that it is here in the section 9 itself, that claim of juvenility can be raised at any.
Correct.
So if that is so, okay, during pendency of my appeal also I can raise. And
Correct.
if that question comes, then the sentence will have no effect of the judgment.
Sentence will have no effect. That is it. The conviction will remain.
Conviction lordship may not observe because also if lordship observes, then if they found me to be adult. And then in that case, I cannot file any revision before the in terms of section.
No, we will have to say that we will have to take a decision with regard to your conviction, whether you are challenging the conviction or if you are not challenging the conviction, we have to record that. That will have to remain. That is clear. We will have to spell it out in black and white, that part. But to take, then let it be released on bail and produced before the court.
JZ court.
You will appear before the juvenile court within 10 days from.
Or it can be produced straight away from the jail on bail.
Yes, your lordship.
Let it go directly to the bomb. Why should you go anywhere? Once you go home, have laddus and all, you will not want to go to the home. Okay, right.
Only give the time frame to position before the, only that
No,
direction.
immediately. Yeah.
Oh, we say immediately from state, one way ticket to the board.
Yes, for a time frame maybe within 10 days or 7 days, you know, put it.
No, we will not give time frame. We'll leave it to them.
No, then.
But you will have to be released immediately. That's not it. Okay, right. Heard, Mister?
Yeah.
Yeah, Ahmed. Give me the appeal. Learned counsel for the appellant. Also heard Ms. B. Buyan, learned AP. This appeal has been filed against the judgment dated 23/6/2022, passed by the Court of the Special Judge, Darang, Mangaldoy, in special bracket POCSO case number 40 of 2020. By which the appellant has been convicted under section 6 of the POCSO Act and sentenced to undergo rigorous imprisonment for 20 years with a fine of rupees 5,000, in default to suffer rigorous imprisonment for 6 months. The brief facts of the case is that in pursuance to an FIR submitted by who is this informant? It was the mother of the victim or
After.
is it? Are you sure? By the FIR submitted on 23/6/2020 by the mother of the victim before the OC Harupetia police station that the appellant had promised to marry the victim whose date of birth was 10/5/2007, had committed, had raped her, due to which the victim became pregnant. Next up. Consequent to the FIR, Harupitia PS case number 238/2020 under section 417/316 IPC, read with section 4 of the POCSO Act, was registered. The investigation of the case. Now, on completion of investigation of the case, the investigating officer submitted its charge sheet, on finding a prima facie case under section 366 IPC, read with section 376(3) IPC and section 4 of the POCSO Act. Is it correct?
That's,
No, that was altered later.
oh, yes. Section
Charge was thereafter framed against the appellant under section 366/376(3) IPC and section 4 of the POCSO.
Lordship, it was altered from 4 to 6.
Correct, that was after the argument.
Yes.
After the argument, the charge was not framed. Under the- Full stop. Next para, the learned trial court after examining the prosecution witnesses, examining 8 prosecution witnesses and after examining the appellant under section 313 CRPC, came to a finding that the appellant was guilty of having committed the offense under section 5 of the POCSO Act. Full stop. Accordingly, the charge under section 4 of the POCSO Act was altered by the learned trial court to section 6 of the POCSO Act. Full stop. The appellant was subsequently convicted under section 6 of the POCSO Act and sentenced as stated in the foregoing paragraphs. Next. During the appellant being aggrieved, filed the present appeal. Full stop. During the pendency of the appeal, The appellant submitted a transfer certificate dated 12/10/2019, issued by the headmaster, Pub Bolabari LP School, wherein it was indicated that his date of birth was 10/1/2003. On the other hand, the FIR had been lodged on 23/6/2022. Which stated that the date of occurrence of the incident of rape had occurred about 5 months back. Full stop. 5 months prior to the 5 months prior to the submission of the FIR. Correct. Full stop. The stand of the appellant in the appeal was that on the date of occurrence of the incident of rape, alleged rape, the appellant was a minor, that is, he was below the age of 18 years. In view of the appellant having taken the plea of juvenility on the date of occurrence of the offense, this court, by order dated 10/5/2023, directed the learned trial court, to cause an inquiry and submit a report with regard to the age of the appellant on the date of occurrence of the alleged rape. Next paragraph. Subsequent to the order passed by this court, the learned trial court, that is Special Judge Dharang Mangaldoy, has submitted where is the report? Huh? It's here. An inquiry slash report dated 14/6/23. 14, 6, 22. Which states that as per the record about the date of birth of the appellant is 10/1/2026. And that as on 23/6/2020, the appellant was 17 years, 5 months, 13 days. Good stuff. Next para. Acha, this is been done on the basis of the transfer certificate.
Initially, there was, we have provided one school certificate, okay, there was inquiry. And during inquiry, there was some discrepancies in the record, so your loss is directed for conducting notification sale. And accordingly, board was constituted, 4 members and chairman, they examined the,
Where is that authentication test?
that report is, one copy was given to us,
8 lakh copies I have.
8/2020.
Okay, here. Next para. On receiving the no, the next para. This court did not accept the inquiry report dated 14/6/2020. As the students admission register number 4 of Hub Bolabari LP School, Rani Pupuri, this is page 9, huh? Page, no, para 9 of the order dated 21/8/2023. Uh, Rani Pupuri 182-603-327. Oh no, 182-603-27502. Huh? Showed that the appellant had been admitted to the school on 3/1/2009 and had joined the school on 3/1/2009 in terms of the school leaving certificate. Dated 12/10/2019. Issued by the school. Post up as such. The records would imply that the appellant, as such, the records had implied that the appellant had passed his class 1 examination in the said school within 4.5 months. that is on 20/05/2009. This fact was clearly, no, as such, as such, this court directed that an ossification test could be conducted on the appellant in view of section 94 of the Juvenile Justice Care and Protection of Children Rights Law Act, 2015, hereinafter referred to as the 2015 Act. The learned trial court was accordingly directed to take steps for constitution of a medical board to conduct the ossification test on the appellant and to submit the ossification test report thereafter. From a wide order dated 21/8/2023, passed by this court. Subsequent to the above facts, events, above facts, the ossification test report dated, ossification test report number MCH/23/2379 dated 8/9/2023, passed by, no, issued by the Superintendent Mongoldoy Civil Hospital, has been forwarded to this court through a forwarding letter number DJ bracket D 6616 dated 15/9/23. This one, no? This one. This orange one. 15/9/23. By the District and Section Judge in charge, Darang Mongoldoy. The ossification test report shows that the age of the appellant was around 18-20 years. In view of the above, it is quite apparent that the age of the appellant was below 18 years at the time of occurrence of the alleged rape.
Yes. May I write?
Yes,
I have given the copies, the benefit, the plus minus,
yes, yes,
one of the
Yes.
judgment, two plus minus two, one of the
Yes, yes.
plus minus.
Very good.
I did a copy.
Next
No,
para.
belek belek, tata. Bukan belek belek, tata.
In the case of Bala Saheb versus the state of Maharashtra, 1994, criminal LJ 3044. The division bench of the Bombay High Court has, where is that?
Mark.
Has held that according to Modi's Medical Jurisprudence and Toxicology, bracket 21st edition, where close, it is observed that the error in case of age based on ossification test may be +3 years. This is +3 years. What about minus?
Jayamat.
Next para. No, in the case of Jayamala versus Home Secretary, Government of Jammu and Kashmir and others. The Supreme Court has 1982 2 SEC 538. The Supreme Court has held that one can take judicial notice that the margin of error in age ascertained by radiological examination is 2 years on either side. Next part. So where's the Bombay is not necessary there. Bombay you cut. No need. Next part. In view of the above ossification test result and the margin of error that can be taken either way, comma. And without even taking into account the margin of error that could be considered by this court, comma. The appellant's age would have to be taken to be below 18 years at the time of the alleged incident of rape. The question that now has to be answered is with regard to whether the with regard to what further steps is required to be done in a case of this nature, where conviction has been made by the learned trial court and the age of the perpetrator of the crime has been found to be below 18 years during pendency of the appeal, in terms of section 94 of the JJ Act 2015. The question of whether this court would have jurisdiction to interfere with the conviction of the appellant and sentence as the appellant has been found to be a juvenile at the time of the alleged crime would have to be decided. Next paragraph. At this stage, Mr. B. Ahmed, A. Ahmed, learned counsel for the appellant, submits that the appellant is not making any challenge to the conviction of the appellant. However, the sentence imposed upon the appellant would have to be, it cannot be sustained in view of the embargo provided in section 18, section 9, subclause 3, read with section 18 of the JJ Act 2015, which provides that. Which provides what?
2G, 18G. that
18G, which
18.
provides that. 18, which provides that a child can be sent to a special home for a period not exceeding 3 years. For providing reformative services. Correct? That's all I think. Next step. Madam, where is your judge? Next para.
Karan.
Huh?
Karan,
Miss B. Buyan. The learned APP submits that the issue has been settled by the Supreme Court in the case of where have I put it? In the case of Karan alias Patia, Fatiya versus State of Madhya Pradesh, 2023, 5 SCC 504. Wherein it has been held that the conviction would remain, but the sentence would have to be set aside. Correct? So, next.
there are 39. In this case, Honorable Court observe, further as the appellant at present would be more than 20 years. I don't know about the age of the present appellant. There should be no requirement of sending him to JJP or any other child care facility or. Let the JJP decide.
Let him go. We'll just see that. She submits that. Where is the question of bail? Is it required bail? Would bail be required now?
Because it is locked in jail, and cannot be locked in jail when it is found that it is.
No, that's what. Won't it be simple release?
Because I have faced one, I was faced one judgment of our High Court, for your Lordship of Sasha. That Umed Ali judgment is there for it. Umed Ali. Found by our division of power.
Yes.
Last week
That
also
case
he did a
also-
case, before court number 5.
Yes.
Released
Okay.
on bail
So
and he was
released on bail.
to appear.
No, I'm thinking, why should he be released on bail? Why not let him go? That's what I'm thinking. If he has completed 3 years, where's the requirement of bail? Because his period has already undergone.
If your Lordship disposing of, then no case of bail.
But
Affect the judgment because in case the fact that it is judgment will not stand. The moment
no, sentence will not stand, conviction will stand. We
Satisfied.
cannot set aside the judgment.
this trial has been initiated in view of the fact that it
He's not challenging that. He's not challenging the conviction.
anyway more than 3 years.
Lordship, let the he be placed before JJP.
We'll say let him be released and be taken before the JJB straight away. No bail, no bail.
Immediately he'll be placed.
Let him go release,
Yes.
release and take him straight there. Where,
From the jail to.
because he's already completed 3 years. I don't know why we should be bail. There was a question of bail. I think the court job has finished now. Let the jail authorities take him straight to the JJB.
He'll pass the court. They will pass the
Why
court.
should he be released on bail? We released fully, in fact. Even some tandoori chicken maybe. Actually, unfortunately for you, it appears that you have had a uh, you have a consensual relationship with the lady. Unfortunately, she was too young.
They were from
It appears so. And the child must have been born now.
5 months, Aksita.
Huh?
5 months.
5 months.
5 months in 2020.
madam.
So now there will be around 3 years. You go and give present or something to her. You've got to take responsibility of your actions. Tell your client, he has to be responsible. Lucky for him, he's also been found juvenile. Otherwise, that's the trouble. Today I was reading in the papers that though child marriage has come down a lot. In all India now, as per the health ministry's report, 1 out of 6 children are still child children. The number of males who are minors are very less, around 12 lakh or 7 lakh. I'm not. But the number of uh, these girls are 1.3 crores or something. But still, all over India, 1.3 children, female, they are getting married.
Probably because of this type of cases, but your lordship has seen that both were below 18 years.
Ah,
And, one case is pending for honorable effect. So regarding the consent part between 16 to 18 years. And the honorable effect for also issued notice to the union regarding this.
No, no.
That it is pending.
Law Commission's report is there. That has been
It is pending.
objected.
I have seen, I can tell for your lordship.
That has been objected.
but then nowadays you've got to be more practical. You've got to be more practical. Everything is on the internet. I'm telling you, everything is there in the internet. We cannot pretend that we are, holier than thou and not know anything about it. It is there in the internet. Everyone can see it. All your children can see it. Anyone who has got a phone can just go in. I mean, and children are not stupid. If you have any problem with your phone, you tell the children to solve it, they'll solve it. They'll do it. Your computer, anything. So we have got to relook maybe, have a relook. Anyway, so where are we? She submits that. The appellant may be taken to the Juvenile Justice Board to take a decision on the future of the appellant in terms of Section 18G of the JJ Act 2015, of the 2015 Act. No, 2015. We have heard the learned counsel for the party. The impugned judgment had been passed by the learned trial court on
23/6/2015.
Huh?
23/6/2015.
23/6/22.
For the 22 judgment,
And as such, the appellant would have been in custody.
He is in custody from.
No, just a minute. It is custody. Subsequent to the impugned judgment, consequent to the impugned judgment, for how many months? For 2020,
He was
26,
arrested on
23/6/22. 23/6/22, then 23/6/23. Then
was kept as after trial, within time charge was submitted. So he was initially arrested on 30/06/2020.
so 1 year, 5 months, 1 year, 5 months, And today is 18th, 5 months. uh, And 25 days, as on today, would have been in prison as a convict for 1 year, 5 months, 25 days, as on today.
I have not gone through the records whether he
No,
was.
now we're going to see, now there's still a record.
In judgment, second page, your lordship will find his period of. In judgment, second page, 36/2020.
36, not 23/6, 36.
No, Lord. You are arrested
no,
on
he was
30/06/2020.
36/20 he was arrested. And he's been in jail since then.
I have not gone through the.
Okay. Post upon, where is the, where's the record?
No. They only that, but. It's.
Oh, he's been there since 36. Full stop. The impugned judgment dated. The impugned judgment dated 23/6/2022, passed by the London Trial Court at para 39 has clearly stated that the appellant has been in jail since 30/06/2020. In view of the above fact, it is quite apparent that the appellant has been in jail for more than 3 years as on date. For more than 3 years, 5 months. 3 years, 5 months as on date. Next. In the case of Karan alias Patia Supra, the Supreme Court was to decide whether courts would have the jurisdiction to interfere with the conviction and sentence given to an accused who had been found to be a juvenile during the pendency of the appeal. In this regard, it may first be mentioned that there had been conflicting decisions of the Supreme Court with regard to whether the conviction against an accused who was subsequently found to be a juvenile was sustainable. Full stop. In the case of Union of India and others versus Ramesh Bishnoi, 2019, 19 SEC 710. The Supreme Court has held that the conviction should be obliterated so that there is no stigma upon the person who committed the crime, who is a juvenile. First off, however, in a subsequent judgment passed by the Supreme Court in a subsequent judgment in Satya Deo, Satyadeo versus State of UP, 2020 10 SCC 555. The Supreme Court had upheld the conviction, and after setting aside the sentence of life imprisonment awarded to the appellant juvenile, had directed the jail authorities to produce the appellant before the Juvenile Justice Board. Whereupon the JJB was to pass appropriate orders regarding the detention and custody of the appellant. The Supreme Court, next para, the Supreme Court in Kiran alias Patia, Supra, Patia, Fatiya, was to consider the fate of the appellant juvenile who had been awarded the death sentence, who had been awarded, who had been convicted under section 302 and 201 IPC. In the above case also, the appellant had chosen not to challenge the conviction and had only made a challenge to the sentence imposed. In the present case also, the challenge has been made only to the sentence awarded to the appellant and not to the conviction and not to his conviction in terms of the impugned judgment passed by the learned trial. The Supreme Court in the case of Karan alias Patia has held that the conviction of an appellant who was subsequently found to be a minor during the appeal proceeding cannot be held to be vitiated in law, comma, merely because the inquiry was not conducted by the Juvenile Justice Board, JJB. It is only the question of sentence for which the provisions of the 2015 Act would be affected. And any sentence in excess of what is permissible under the 2015 Act would have to be accordingly amended as per the provisions of the 2015 Act. The Supreme Court further held that no, no, I have to stop. The reading of the judgment quoted above, stated above, clearly shows that while the merits of a conviction upon a accused who is subsequently found to be a juvenile can be tested, comma, the same does not, the conviction does not automatically become vitiated just because the accused is a juvenile. The only thing that automatically, the only thing that is, that has to be automatically set aside is the sentence. The question of whether the conviction was legal and valid would have to be decided on the touchstone of the facts and circumstances of the case and the evidence adduced by the learned tribe. In the present case, comma, there being no challenge to the conviction of the appellant, comma, we uphold the impugned judgment passed by the learned trial court in convicting the appellant under Section 6 of the POCSO Act 2012. So, however, as the appellant was a juvenile at the time of the occurrence of the crime, in terms of the ossification test dated 8/9/2023, comma, the sentence awarded to the appellant could not have been given to him in terms of the 2015 Act. Accordingly, the sentence is hereby set aside. As the, before that, before we say all that, somewhere I have mentioned that regarding this Karan Alayat Patiana, just put this paragraph 35 36 and 37 of the above judgment passed in Karan Alayat Patia Supra is reproduced below. Okay, that's good. Next paragraph, what have we said? Set aside. The as the appellant has already undergone more than 3 years in judicial custody. The appellant. No, the respondents are directed to release the petitioner appellant immediately from jail and produce him immediately thereafter before the judicial, before the judge, JJB. JJB, who shall take a decision with regard to the future course of action in terms of section 18, section 18 of the 2015 Act. The appeal is accordingly disposed of, as indicated above. Send back the LCR. Okay. Somewhere you put the JJB Act. I think we'll have to reproduce JJB Act. I think section 18 is enough, I think. Somewhere after that you produce the thing, no? After you produce the thing, after that judge report, you put this also. Section 18 of the 2015 Act is reproduced below as follows. It will take some time for your order will not come immediately. It will take some time. Because the problem is this will take time. I have to correct it all. And I'm leaving for Mizoram tomorrow morning flight. Probably will not be able to complete. I'll try to finish it by then, and my sister will pronounce the order. I mean, the order is pronounced, but we'll try to finish it by within this week. But it'll take some time.
So what we are looking at,
Yeah.
if you are directed to submit the records immediately, because if the records are not there, JJB will not
Okay.
process it.
Yes, right. Send back the LCR to the learned trial court immediately. Yes, sir?
Lordship, not providing copy to my learned fair. State of Assam do not have so much of resources. Even a lordship's copy have not provided, ST has provided it.
What?
Lordship's still no offense with the council.
Regarding the judgment.
Oh,
I don't say something.
yes. Any undisposed, I just say in view of the order passed in the main appeal, the IA is also accordingly disposed of.
Lordship, in this case, record was called for. Lordship, record has come in connection
Item-
with another
item
criminal
10.
appeal, Lordship. I have seen the office note dated 11/12/2023. Original records were sent in connection with criminal appeal 259 of 2020.
Huh?
Original,
LCR has been sent in criminal appeal 259,
yes, but
2023.
that is not before your lordship.
Yeah. Anyway, so yeah, yes, what is this?
I dear Lordship,
Yes.
and that's for a moment Lordship. That
My
in
lord,
this case,
lordship,
Lordship
last
said that
occasion the matter came up. There is a judicial order of His Honorable Court dated 5/2023. IA to be considered on receipt of LCR. Therefore,
So-
order dated 28.
So this is us only. This is us only. What is us? Three,
It was the
we,
case of yesterday.
we have got the, we can change this. 482,
Change it, my lord.
yes, we can hear it
Sir,
without the
record-
LCR.
Records are not before your lordship.
The judgment is there.
exactly.
Lordship may take into account the evidence and records, but because there is an order. While considering the IA.
We will consider. Okay, he's having difficulty. What to do?
Without the records are not before. Let them
Lordship,
make a
otherwise,
proposal for public.
Lordship, that otherwise Lordship at the earlier occasion Lordship at well supposed to be granted because on the basis of the observation made in the judgment and the present appellant having no any involvement at all, and even then Lordship, the 8 numbers of witnesses are examined. And cross is there, and all the observation is made by the learned court below in the judgment. Nothing corroborated against the present appellant person, but here are the 7 persons, and nobody is take his name, Lord.
Nobody.
And even then, Lordship, and Lordship, 1 minute. And Lordship, the PW1 is the father of the deceased, Lordship, and he is the informant. And the PW2 is the son of the deceased, and he is the elder brother of the informant, Lordship. And first thing, Lordship, PW2, and he went to the place of occurrence after 5 to 10 minutes. And the PW1 was there, and he said his father was dead. The PW1 informant said. And after 5 to 10 minutes, his elder brother, the PW2, Aminul Islam, and he went to the place of occurrence, but his father was not dead, and his father was alive. And number 1, Lordship, and the PW
No, Mr. Counsel,
Lordship.
you are starting off arguing straight away. We have got no problem whatsoever to hear it. Only problem is with the APP.
No, not
He is
the
asking-
APP. The judicial order came in between, which says,
Judicial
my
order,
lord,
we can always.
I
take
will be
that.
considered on receipt of LCR. Lordship, on that occasion only, the learned court didn't take up the matter. The last occasion, the matter came up.
Let it come. Okay, right.
Along with the records, it may come. I have no objection.
He wants to go, this is a holiday season coming up.
So, Lordship,
Their personal liberty. He wants Christmas season is coming up, then Bihu is coming up. Ah,
then he is a convict of 302 and 34, your Lordship, that we should not.
but then
forget.
he says that his name is not reflected in anywhere.
So, records will read it, your Lordship.
Okay, we'll list it. Okay, we'll list it with the record.
Someone will be convicted, Lordship. And what is his involvement is first necessity to observe.
Mr. Counsel, on the other hand, you've got to keep in mind the fact that the learned trial court did not convict you just out of the blue.
Sure.
It was based on some evidence.
Sure.
So that way also you've got to understand. You see, it's not a case where you were not convicted. It's a case
Yeah.
where you were convicted.
And Lordship, there is doctor is there, Lordship, and the informant says the heavy wooden piece and he assaulted his father. But doctor says that in his opinion, there is no any external injury.
Okay, right. In the IA, you're right. Office note dated 11/12/2023 passed in the main appeal states that original records have been received by the registry in connection with criminal appeal number 259/2023. In view of the above, tag this case along with criminal appeal 259/2023 on,
Immediately.
give a date after the vacation. What to do?
Before people go to can you please?
Ah, oh. When? You give a date. We'll give you the date, 5th, 5th January.
I for condonation of delay of 2 days only, my lord, for criminal appeal, my lord.
Mr.
Sri Gostami.
Mr. C. Goswami, learned counsel for the applicant submits that there's a delay of 2 days in filing the appeal against the judgment dated 7/8/23 passed in sessions case number passed by the additional sessions judge cum special judge Pokso Kamrup M in sessions case number 420/2018. Miss S.H. Bora, additional PP submits that she has got no objection to the delay being condoned. The delay is accordingly condoned. Registry is to register the appeal and only the appeal,
Yes, ma'am.
the appeal, and list the same thereafter. I accordingly dispose of.
Obliged.
Yeah, please. What is that? High for. One more, 150. 150.
So my lord, I have.
120. Conviction, huh?
Delay to will allow. Okay. Same thing, third Mr.
Just for now.
S. Sharma, learned counsel for the applicant, who submits that there is a delay of 128 days in filing the appeal against the judgment dated 24/5/2023, passed by the additional sessions judge cum special judge POCSO Shipsagar in special POCSO case number 2 of 2023, convicting the appellant under section 6 of the POCSO Act. Miss Selpa, same thing, does not have.
Take your best.
May I please vote? IA is pending in appeal number 301 of the 23. In the appellant, he was convicted under section 302 by 34 for life.
So what is to be done?
But they will kindly see two alleged diabetes.
Asha, you want the IA to be disposed?
IA to be disposed of.
There is one IA.
Other two are jail appeal. There are three accused appellants. This appellant is preferred,
He is Pranab.
he is one of Hati Bodwa. Hati Bodwa. Now other two are jail appeal. Hopefully they have not filed any IA.
Here for?
Item number 19 and
Oh,
20.
So 18, 19, 19, 20, we cannot do anything. That will be for hearing. है ना?
That's because it was tagged, that's why it is.
So now, yes,
The allegation is basically Lordship on 31/8/18, while the informant's brother, the deceased, he was coming on a tempo. He was waylaid in the near Melenga Tea Garden, and these three accused appellant they assaulted, and thereafter he succumbed. That is the allegation of the prosecution story. Now your Lordship kindly say PW 13 is one of the eyewitness to the offense.
yes.
But we have not received the paper.
The paper book is ready. We have received.
Ready, but I have not received. Nobody has been. Nobody
Yes, sir,
has.
is there a extra copy?
It's an error. But I have got the evidence copy of it. Page I
No,
can.
no, it is there. We'll give you the extra
We have
copy.
not been supplied.
I have
Wait.
received.
You have received.
Yes, it's, but we have not.
That's it, right here. We don't know.
They have also not.
This is not POCSO, no?
No, my lord.
This
This
is,
is-
give it to, give it to. Wait, sir, just a minute. Give it.
Here you'll also kindly come to the evidence of PW 30.
Have you been given paper book?
No, see, here also not.
Oh, none of them have been given.
None of the appellants is
Then you have to give that back to us. I thought only you did not have it.
for argument.
Because then we'll tell them to make copies.
Lordship pass an order.
Yes, I'll just be back from that.
Lordship kindly come to page 40.
Page?
40, 40.
Yes.
There's PW 13, who is the eyewitness to the offense. I know three accused persons were present in the dock of the court today. That's it.
Yes.
I know that three accused persons were present in the dock of the court today. On being asked, one accused identified himself as Sri Pranab Khatibodwa. He is the present appellant. The other accused identified himself as Subhash Dey and Manoranjan Khatibodwa. The occurrence took place about 1 year back. On the date of incident, I was walking at Chokidar near the main gate of Melang Tea Estate. The occurrence took place about 7 p.m. at night. I know that this is Deva Borguhai. I do not know the name of the informant Sanjay Borguhai. At the time of occurrence, I was sitting near the gate of Melang Tea Estate with a wooden lathi in my hand. Then one tempo came there and stopped near us. Then I went near the tempo. While I reached there, all the three accused got hold of Deva Borguhai. And accused Pranav Hatibora has taken by my wooden lathi from my hand and assaulted Deva Borguhai over his head, stomach in my presence. The other two accused persons were also with the accused Pranav Hatibora, and after assaulting Deva Buraguhai, all the three fled away from there, leaving the wooden lathi at the place of crime. After the assault, Deva Buraguhai fell down near the tempo. After the offense, manager Diwari and one Gogo arrived there. They have been injured and thereafter left the place of offense. Thereafter, many people assembled there. The manager inquired about the offense from me, and I have narrated the offense to him in detail. Thereafter, someone. Now, this part he has never stated before the police regarding me taking the lathi from his hand and assaulting that.
Did you put
That was
petition
put.
to him?
That was put, and the IO has put the contract.
No, not the IO, to him also.
To him also, Lordship. It is there. It is down portion. It was on not. I did not state before police after assaulting the accused cheer with a wooden lathi at the place of offense. Not a fact I did not state before all
Okay,
the
let
three-
us see the IO.
IO now PW 18.
Yeah.
PW 18 page 56. Lordship. Witness Bubai Ganju, he is PW 13. During his statement under section 161 CRPC, did not state before me that all the three accused persons dragged the deceased from inside the tempo. This witness also did not state before me the accused Pranav Hatibora, the present apparent, assaulted Deva Burana with a wooden lathi. Thereafter assaulting Deva Burana, the accused cheer with a wooden lathi at the place of offense. It is a fact that witness Babuai Gunjar did not state before me that after the offense of assault caused by Deva Burana by three accused when they fled away from the spot at the time of manager Tiwari and Goy came there and asked him about the incident. To their query, he narrated the incident to them and both of them stated before him not to go near the place of offense. The whole part that was not stated before that. For the first time in court, he has stated. And only on the basis of this statement, he has been convicted.
What of any other witness?
Any another witness is there, PW 15. But PW 13 doesn't say that he was also present at the place of offense. PW 15, page 45, you also can see. Puni Bowdy. I know the three accused persons were present in dock of the court today. On being asked, one accused identify himself as Pranav so. The offense took place about 1 year back at night at about 8 p.m. He stays about 8 p.m. On the date of occurrence, I along with one Bubai Ganju, is PW 13. But PW 13 doesn't say that he was along with him. His present witness was along with him, he doesn't say. I along with Bubai Ganju were attending duties near the main gate of Melang Tea Estate. The occurrence took place near the Radhakrishna Mandir, which is adjacent to the main gate of Melang Tea Estate. Then all the three accused snatched the wooden lathi from the hand of Bubai Ganju and assaulted the driver of one FA. But I have not seen who had assaulted the driver. So here he states that he has not seen it. Apart from that, Lordship, PW 13 never stated that he was also present with him at the time of. So only on the basis of these two witnesses, Lordship, evidence of these two witnesses, the present appellant says. Apart from that, there are no other.
But then PW 15's statement is not controverted.
So only that part is not, but he has stated, I have not seen who had assaulted driver. So out of these three persons, who has assaulted, he has not seen. And his presence is also doubtful because PW 13, he has not stated that he was also there along with him.
Accused had thrown away the wooden lathi to a pond.
Again, wooden lathi was not found in a drain, not in a pond. Those things are there. But apart from that, the main witness is PW 13. Because they have, according to him, the wooden lathi was transformed him. He was sitting there along with the lathi. He was chokidar. But he never stated that PW 15 was present along.
Anything else?
Only this. And no other evidence.
Let's pick it up actually.
These two are only evidence.
This is, now the whole court work will be stalled because he is not here. That's true. You are convicted. What's your name?
Ranjan Sonowal.
Your name is not here. Your name is not here in the cause title, correct? In the cause list? Okay. Is your name there in the cause list? Are you a counsel?
Oh, MSP.
What is your name?
MSP.
Right. Mr. S. Hussain, heard Mr. S. Hussain, learned counsel for the applicant, who submits there's a delay of 36 days in filing the appeal against the judgment dated 4/7/23, passed by the learned additional district and session judge Dibrugarh, Assam, in sessions case number 151/2014, by which the appellant has been convicted under section 302/34 IPC. Ms. S.H. Bora, learned APP, something that she has got no objection to the delay being condoned. In view of the above, the delay condoned, registry to register the appeal, and this is the same accordingly. I is accordingly disposed of.
Okay.
But the other counsel is. Yes,
This is an appeal arising out of judgment and order dated 1/10/2016, passed by the Honorable District and Session Judge Gulaga under section 32 and 34 of IPC.
isn't that today's M. Barwa and that item? I, M. Bora. Item 7 and 8. Yes,
In this case, the three appellants are there, but one is absconded panel as before framing of charge.
who is the one who absconded?
This Gajendra Tanti,
Rajendra.
yes. Now here two appellants are there, Kireshwar Tanti and Hotal Karmakar, who is in on bail and as
So Kireshwar Tanti is here.
yes.
What happened to the other person?
No, Hotal Karmakar is also
Huh?
here.
No, Rajendra is absconded, but there are three.
Three, one is absconded, Gajendra is absconded, two is there.
Yes, but out here, this appeal has been filed only by one
Okay.
person, no?
No, my lord, two person is there, Hotal Karmakar also there. Here's 91 in the back of it. Here's 91. My lord, Kireshwar Tanti is appellant number 1, he is on bail as per the Honorable Court Order 10/2017 year.
Okay.
This FIR is lodged by the PW number 1, who is the brother of the deceased. May I read, my lord, FIR? The humble submission is that around 7:30 p.m. yesterday, that is on 31/7/2005, the below mentioned accused person seized my elder brother, Sri Diganta Bora, and killed him brutally by dealing blows with dao, axe, hammer, etc. at the playground near my house. After committing the murder, they fled from the place of occurrence. It is therefore they take necessary action after the investigation into the matter. But in this case, my lord, there are 4 eyewitnesses here. PW
Is
number
brother of the deceased, this informant, his PW number?
1, my lord.
One.
May I repeat the PW number 1? I know the accused person about 3 years back, on the day of the incident took place at 6:30 p.m. My elder brother had married accused Thiressa's younger sister. My sister-in-law Aguni Tanti and the elder brother Diganta had frequent quarrels. Then my sister-in-law left.
Just a minute.
Yes.
So this elder brother's name is Diganta
Yes, my lord.
Okay.
This name is Diganta.
and Kireswar's sister is
Aguni.
Aguni. Okay.
Thiressa is my elders, my sister-in-law Aguni Tanti and the elder brother Diganta had frequent quarrels. Then my sister-in-law left her maternal home. When my mother went to bring her back, she refused to come with her. When elder brother went to bring her back, she did not come with him too. One day, when elder brother was going to the market, the accused assaulted him on the way and caused his death. Having heard about brother being assaulted, I went there in a run, found Gajendra Tanti, Hideshwar Tanti, and Badan Tanti. This Patal Karmakar also name is also here minor, the Badan Tanti. Here, I saw Hideshwar armed with a rod, an axe, hammer, a rod, and dove were lying near the elder brother. On seeing me, the Gajendra Tanti and Badan Tanti ran away, but Hideshwar dealt with a blow on my arm with a saying that he would kill me too. Then I snatched the rod from Hideshwar and dealt with 2 blows to him. Hideshwar fell down on the ground. When I called the member of the family, Hideshwar fell from the place. The members of the family came and I saw cut injury caused with axe in elder brother's head and piercing injuries caused with rod in the abdomen and cheek. I came to Golaghat police station and informed the PS of the matter. Police went and brought a dead body. Exhibit 1 is the Azahar lost by me. Exhibit 1 is the signature. Police help in case on the dead body and police seized the dove, axe, and rod found lying near the dead body. Exhibit 2-1 is my signature and Exhibit 2 scissor list. Material Exhibit 1 is the X and Material Exhibit 2 is the hammer. In cross, mother had late elder brother and sister-in-law lived separately. I do not remember the date and the day on which the incident took place. It is not a fact that on the day of the occurrence, my elder brother had tortured sister-in-law by assaulting her. A few days before the incident, sister-in-law had caught fire about 2-3 months before this incident. When elder brother had
Elder sister-in-law had caught fire.
yes,
Oh.
my lord, before this incident, during Bhauna, my lord,
Hearing?
Bhauna, like theoretical performance in Assamese state, Bhauna.
Where? Bhavna? Where?
Uh,
In the house of the
No, no.
husband or in the
No, Bhauna is basically outside. It's like a small.
while she was married? While she was married, she caught fire.
Yeah. A few days before the incident,
During the marriage.
yeah,
Madam, caught fire during the marriage. Probably. Probably.
marriage that is not mentioned here, madam.
Okay. Okay, then.
A few days before the incident, he caught fire about 2-3 months before the incident. When the elder brother had gone enjoy the fauna and had a quarrel there. One is his companion had injured by assaulting him on the dead head with a kukuri. Following that, he was admitted in the hospital. It is not a fact that I did not mention in the Azahar that 3 accused person has assaulted elder brother and that Teresa had assaulted me with a rod and any arm. It is not a fact that I stated before police in this manner. he has a quarreling with his wife last few days. So my mother, them, they have been staying with us for a few days. Today also they fell out during the hours. Diganto often comes to home drunken state. After drinking, he often quarrel with anyone. This afternoon also, he fell out with his mother-in-law and others over some issues. As he gone to quarrel with his his in-laws, mother had followed him and specified that brought him back. It was a moonlight night. It is not. a fact-
Diganta is the husband of that. Diganta is the husband,
Yes,
correct,
yes,
of Aguni.
yes, my lord.
Ah.
It is not a fact that it was a moonlight, but here was a darkness. It is a fact. It is not a fact that I did not tell police that when Teresa Tanti had assaulted me with an iron rod on my arm, I had sneezes that saved rod from him and dealt two blows to me. It is not a fact that I have stated it falsely that receiving the blows, Teresa fell on the ground that following my alarm when the members of my family came. He fled the place. It is not the fact that I did not tell police where in this person my elder brother had received injuries. It is not a fact that I told police that as soon as we arrived, the two person fell.
Okay, let's go to the next evidence.
Yes. Next one is my lord. PW2 is mother of the deceased.
My lord of the deceased. what?
Mother of the deceased.
Oh, mother, okay. Page 11,
Yes, ma'am.
PW2,
Yes, ma'am.
mother of deceased.
Yes.
Okay. Okay,
I-
what is it?
I know the accused. This is Diganta Barai was my son. About 3 years back, one day incident took place at 6 p.m. I was cooking rice at the time of the occurrence. At that time, when my son Bipul raised hue and cry, I went out and came taking a lamp. Going out and I found the son lying near the field. I found Hirasa standing there. Potol was standing a little away from there. Hirasa told me that he had turned Diganta into a dead body. In that state, when the Hirasa again tried to assault people on his head with a rod. People held that saw rod swiftly seeing dead body of Diganta. I became unconscious. My son Diganta married Hiresa's younger sister.
It appears that this Diganta is quite a troublesome fellow. Yes, it is. Anyway, carry on.
Yes, madam. In first part, Diganta had a lot with Hiresa's younger sister Agni and lived as husband and wife. Since Hiresa Tanti belonged to a different community, we had no visiting terms with them. My son used to consume liquor every now and then. Both of them fell out quite often. Even on the day of the occurrence, they had a quarrel and she left her maternal home. On the day of the occurrence, Diganta did not visit the house in his.
Okay, I think there's nothing here left.
Yes, my lord, nothing is there.
Then PW3 is the evidence.
Yes,
Now,
he is a
what
doctor,
is the opinion? Opinion of
his
this?
injuries are deep cut, 15 centimeter into 4.5 centimeter, 3.5 centimeter left over the.
Okay. These
There
are,
are 7
okay, so
injuries.
that is what is the weapon used?
As per the FIR, Act, Hammer, Dow, but the Caesar documents on the my lord Hammer and X. Material acting.
Hammer and axe.
Yes, ma'am.
So that is enough, I think. Hammer and axe is good enough. Injuries described above are caused by sharp weapon. The axe is a sharp weapon. But what?
But as per the PW3 deposition, this Diganta, Teresa Tati has only he has a rod.
Huh?
Rod. Which rod? my,
Who has rod?
as per PW4 reposition.
We have not reached the PW4,
Yes,
madam.
yes.
Okay, so rod.
Yes.
Then,
In the PW4
but weapon and weapon, hammer and
X. Ma'am.
axe was seized,
Yes.
correct?
Yes.
Yes, in PW4, let us see.
Yes, PW4 is Jiten Bora. He's a elder brother of DC also.
Elder brother of,
This is Diganta.
so his name is no Tanti, there is no Tanti here.
Tanti is no here. Because that's why there's a squirrel, I think that because there is the Diganta, Kiresa Tanti and belong to different community. Aguni also different
Who
community.
is a senior, madam? Who is a
Siddharth
senior?
Borgohain.
Huh?
Siddharth Borgohain.
Poor guy. I was thinking why she has sent you.
No, my lord, he is not well. That's why he's under medical observation, my lord. That's why.
Okay, carry on.
PW4, Diganta, Jiten Bora. I know the accused. This is Diganta Bora was my elder brother. He died 4.5 years ago. The incident took place at 6:30 p.m. That day, when we sat on have our dinner in the evening, the elder brother had gone to the shop. Hearing hue and cry and the sound beating near our house. The elder brother, Bipul Bora, and I went out of their house. Going there, we found Kiresar and cousin Karmakar and Pakal Karmakar were assaulted Diganta with axe hammer and a rod. Kiresar Kati was armed with a rod, while Pakal and cousin were armed axe and hammer respectively. Although the Kiresar Tanti seized me and dealt a blow with rod, the blow did not land on me and I had moved aside. Then Kiresar dealt the blow people with the rod. Hereafter, when people dealt 2 blows, Kiresar with fence post and ran away from the place. Diganta died on the spot and when informed police came here. In prose, Diganta and this is Diganta married to this is Diganta and married Kiresar's younger sister. The members of the family did not give consent to their marriage. Since Diganta had married a girl, the bad report grew between the accused person family and us. Diganta with his wife and had lived separately from us. Diganta's wife has a Aguni Tanti. Police did not question regarding this incident. The place of occurrence is about 100 meters away from our house. At first, Bipul and I went place of occurrence. It is not the fact that I have stated it falsely going to the place of occurrence. I have seen Patal, Kiresar and cousin dealing with blows with axe, rod and hammer. A few days before the incident, one Kalia Das badly injured in Diganta, cutting him head with a kukri. Following a quarrel took place during the performance of Bhavna. He received 6-7 stitches in the head. It is not the fact that I have stated falsely that Kiresar has charged at me in order to assault and that when you could not be assault me. He had assaulted people. It is not the fact that people had not assaulted Kiresar with bamboo peg and the Kiresar was not even present at the place of occurrence. It is not the fact that I have falsely lost this case against the accused person following.
Okay, we'll take it up at 2, I think.
Yes, my lord.
I think you've got a uphill task.
Yes.
Some people go like this very fast. They have to go like this. Very difficult.
Yes.
Yes.
14 months.
Yes.
Some difficulty, but can it be near the pavement?
Why? What's the difficult?
I was there, but second
Huh?
have to go.
They're prepared. The eyewitness is there. That's why you're not prepared.
No, Advocate is not there.
I was not there.
It's a hostile witness and my lord. 161 has been executed.
Based on extrajudicial completion and circumstantial evidence, ample of evidence.
What to do? They were not finished it out.
Like,
Take time.
evidence to find the
Where's
police.
your lordship witness?
Okay, right. On the prayer for adjournment made by Mr.
N. Mahajan.
Mahajan. This is the matter after the meeting.
Item 14.
14.
Obliged.
Yes, so what is your case?
Case was regarding PW 13 and 15, I have already read. For the first time in court, they have stated that he has seen me assaulting me and the other accused assaulting that. For the
Yes.
first time in court.
There are
That-
3 eyewitnesses to the occurrence according to me, your lordship, 13, 15 and 16.
16 also.
16 said that somebody else, not me. But the only thing is that PW 13 has not stated the presence of other two. 16 is with regard to Manoranjan Hatipur, not me.
16 Vinod Chittian from the
Like,
lordship, yes.
Manoranjan Hatipur.
He
One of-
witnessed all the accused persons talking with one Devo, a driver, and he also noticed one lathi in the hand of accused Manoranjan Hatipura, who gave one blow to the opposite ape driver on his left hand. He has further stated that the incident took place near Radhakrishna Mandir, at Meleng area. Seeing the incident of assault, they fled away from there and later on he came to.
So
know-
Manoranjan gave a blow.
Yes. It is
But
there
that is
about
also-
lordship common intention.
That also your lordship will kindly see from PW 18 for the first time in court, page 56.
Yes.
Witness Vinod Chetya, PW 16, during his statement under section 161, did not state before me that he has also seen one lathi in the hand of. Akil Mohammed Monzo gave one to one.
May I see the 161 also?
Yeah.
It's not permissible. Because of the,
That-
because of the
IO has admitted
IO
for the
lordship,
court.
the case should not fall, my lord, when there are direct eyewitness.
This is not for.
Let us see in the 161, you see.
We are bail. now.
Only 16 to all the witnesses, PW.
No, his
No, no.
case is only with regard to 13,
And
13?
15,
15 and
13 I
16.
have seen already.
13, 15.
16 with regard to Monoranjan, not me. I'm-
He's not Manoranjan.
I am
He's-
Pranab Rakhi,
13 Dubai 20.
which he is a
মোৰ নাম আৰু ঠিকনা ওপৰত উল্লেখ কৰা মতে সত্য মই আৰু মই আৰু some police written here. Do I
My sister will understand. Huh?
Yes. 31/8/2018 তাৰিখে মন্দিৰৰ এক নম্বৰ পিছত 12 বজাৰ পৰা ৰাতি 12 বজালৈকে আছিলো। সেইদিনা ৰাতি 7:45 মান বজাত মন্দিৰৰ ওচৰত তিনিআলিৰ ওচৰতে তিনিজন ল'ৰা এজনক মাৰপিট কৰিব ধৰিছে। মই দেখি আগবাঢ়ি গৈ সিহঁতক যাওঁতে তাৰ এজনে মোৰ হাতৰ লাঠিডাল নি এজনক মৰিয়াই পকী ৰাস্তাত পেলাই দিয়ে। This seems to be he is the eyewitness according to
No, he has not seen it.
lordship, but there is dog identification.
No, that's,
It's there.
TFP
May
was
I
not
see?
there. Again, TFP was not.
Lordship,
first
because
time.
he is there.
Let us see where
Yes, he has seen, my lord. ডাল নি এজনক মৰিয়াই পকী ৰাস্তাত পেলাই দিয়ে। According to him, the victim was assaulted by মোৰ হাতৰ এজনক মৰিয়াই পঠিয়াই দিয়ে। মাৰি দিয়াত ল'ৰাজনৰ মাত কথা নাইকিয়া হৈ যায়। That victim became senseless, my lord, when the assault was made. তাৰপিছত লাঠিডাল ওচৰতে থকা সলনি দলিয়াই দিয়ে। মই ভয়তে গুচি আহি পুনৰ ওচৰত গৈ থাকো। আজি ইংৰাজী he has seen, my lord, lordship is at the
He will kindly
and there is lordship dog identification. He is
whether your
identified.
lordship
He
will
has
by the,
written, my lord.
by the evidence of 161 statement.
Dog identification. Here, when the accused person were on the dog, he identified. He has written here. ল'ৰা কেইজনৰ নাম নেজানো, দেখিলে চিনি পাম। ল'ৰা কেইজনক দেখুৱাতে চিনি পাওঁ বুলি আশা
Whether TIP was held.
Why? he is a witness without reserve.
We cannot go now into the 161 statement. What is behind the evidence, we'll have to go by that. Judgment will have to be pronounced on the basis of case, not on the basis of 161 statement.
But your lordship, whether may I read their evidence? PW 30.
Read the evidence.
Is the paper which
Page
is here?
40, page 40.
Photo video बनाए।
no TIP done.
There's a defect on the part of the prosecution that will not give any benefit to the accused person. And there direct eyewitness is your lordship.
He has not stated.
Evidence of PW 13 at page 40. I know the three accused persons who are present in the dock of the court today. The witness identified all the three accused in the dock. On being asked, one accused identified himself as Sri Pranav Hatipurwa. The other accused identified themselves as Subhash Day and Sri Manoranjan Hatipurwa. The occurrence took place about 1 year back. On the date of incident, I was working at Chowkidar near the main gate at Melenki Estate. The occurrence took place about 7 p.m. night. I know that this is Debo Borgohai. I do not know the name of the informant Sanjeev Borgohai. At the time of occurrence, I was sitting near the gate of Melanki estate. He was the chowkidar, my lord, with a wooden lathi in my hand. And then one tempo came there and stopped near us. Then I went near the tempo, and while I reached there, all the three accused caught hold of Debo Borgohai. And accused Sri Pranab Bhatipura has taken my wooden lathi from my hand and assaulted Debo Borgohai over his chest and stomach in my presence. The other two accused persons were also with accused Pranav Hatiburua. And after assaulting Debo Borgohai, all the three fled away from there, leaving the wooden lathi at the place of occurrence. After the assault, Debo Borgohai fell down near the temple. After the occurrence, manager Deuri and one Gogoi arrived at there, and they have seen the injured and thereafter left the place of occurrence. Thereafter, many people assembled there. The manager inquired about the occurrence from me and have narrated the occurrence to him in detail. Thereafter, someone has taken the injured to the hospital. On the next day, police arrived at the place of occurrence, seized the wooden lathi, preparing scissor list. Material exhibit 3 is the said wooden lathi, which I have seen today in the court. Exhibit 8 is the scissor list, and exhibit 8.1 is my signature. I was flush-shipped and the cross-examination part. I was taken to the police station by police and interrogated me. It is not a fact that I did not state before police that on the date of incident I was present at the main gate of Melanki Estate walking at Chowkidar. I did not state before police about arrival of tempo as police did not ask me about the same. It is also not a fact that I did not state before police that all the three accused dragged out the deceased from inside the tempo. It is not a fact that I did not state before the police of assaulting Debo Borgohai by accused Pranab Hatibura with a wooden lathi. It is not a fact that I did not identify the accused at the police station. It is also not a fact that I did not state before the police after assaulting Debo Borgohai. The accused threw away the wooden lathi and left lordship, although he did not name, because he said he can identify if they see him. An identification is made in the court itself, my lord. He witnessed the incident. He will not know because he is the chowkidar of a tea estate. And one of the circumstances your lordship will kindly take into account, my lord, they surrendered subsequently before the police station. Why did they surrender, my lord? All the three accused persons surrendered.
Yes, you surrendered before the police station. Huh? Why?
That is of the police was searching for us, we surrendered. That cannot be a evidence against us, just because we have surrendered. That you'll also kindly see, incident occurrence took place in 18 and 2020 evidence was recorded. So after 2 years, almost 2 years, we have been identified. No TIP is held. Even contradiction we have losses already seen. Ultimately, losses will know the fate of the case. And these witnesses have not stated the presence of other two witnesses. Main star witness.
No, what is the police? PW only.
There is 164 statements before.
That has not been executed. That in a judgment court.
Okay, so, third pista,
Detail.
he Talukdar learned counsel for the applicant. Also heard with the Boyan, learned APP. Hearing concluded, order reserved on the application under section 39 CRPC.
Paper book direction your working kindly.
Give us the paper book. Then in the main appeal, you write. Ms. B. Boyan, learned APP submits that paper book has been received by her. On the other hand, the counsels for the appellants,
All the three appellants.
of all the three appellants, submit that they have not received copies of the paper book. I just need to supply copies of the paper book to the counsel for the three appellants. Release the matter after the appeal.
Mark.
This legal. But if I have received from the instruction from Mr. Rai, from my senior, he will conduct the case.
We have heard you, madam. You cannot just be. What do you mean he will conduct the case? On the last, have you seen the last court order?
Yes, my lord, that's why I am prepared.
Huh?
Therefore, I am prepared before this.
They are prepared. No. You just cannot adjourn all the time. You have been adjourning it for the last 8 times.
Yes,
What we about? Huh? No, there's hardly anything. We have heard you. Anything else?
please see, I have before this, I've noted up PW number 4. Page 16, sir.
Yes.
I know both the accused. This is Diganta Bora was my elder brother. He died about 4.5 years ago. The incident took place about 6:30 p.m.
Yeah, so this is a witness, we know.
Yeah.
Yes. What do you want to say?
By that,
This is the eyewitness, he's seen them assaulting.
yes,
Then-
but there are 9 witnesses. 4 are as per the witness, 4 witnesses are eyewitness.
Which are the eyewitnesses?
PW 4, 4, 7, 1, 4, yes, madam. 4, 1, 2, and
147?
Yes.
Anyone else? There are only 3.
no. According to judgment, madam, PW 1, 2, 4, and 7. PW 2.
No, 2 is not a eyewitness.
As per the judgment, sir, PW 1,
Hmm.
who is mother of disease. But there is no independent witness.
Okay, wait, 2. Acha, only that Kireshwar told me that he had turned Diganta into a dead body. So that's an extrajudicial confession. That's all. So why should he be considered to be innocent? Why should they be considered to be innocent?
I don't, as far as my knowledge is concerned, my lord, there is a quarrel between this appellant sister-in-law and appellant sister and his disease, disease, Diganta Bara. So for that reason, I not this incident is happened
Incident occurred due to quarrel between
between this appellant sister and brother-in-law, that is disease, my lord, Diganta Bara.
and so you took revenge.
Yes, my lord, out of previous years, my lord, maybe such provocation,
The evidence, where is the evidence that sudden provocation is there?
yes, not.
So exceptions to 300 to prove it, you've got to show some evidence.
PW, 5 and 6, my lord, TRC evidence, my lord. And, PW 7 also is. But quarrel between the wife and that this is a quarrel part is clear, my lord. There is quarrel between husband and wife, my lord.
So both of you have been convicted under 302,
And before my.
34. So for life,
For life.
nothing below life can be given. Correct? Can anything below life be given? Anything else? Anything else, madam? No judgment, nothing. Yes,
There are 3 eyewitnesses to the occurrence, my lord.
Yes.
PW 1, 4 and 5.
1, 4 and 5,
5.
not 7.
1, 4 and 7. 1, 4 and 7. And there is extrajudicial confession before PW 2. So I think these are the, I will not elaborate myself. My lord, these are sufficient to offend the conviction and lordship may not interfere with the order of conviction because the victim was 20 years old, your lordship, and if the lordship sees the nature of injury, I know. So lordship, the state is rightly given, your lordship.
Victim was 20 years old.
Yes, my lord.
I know. Wound's position and character at page 73. Deep cut wound 15 cm, 4.5 cm, 3.5 over lip, occipital region and fracture of underlying bone. Cut wound 5 cm, 4 cm, 2 cm parallel to wound above with fracture of lip, occipital. Cut wound so and so over left side of cheek with fracture of lip mandible. Injuries describable are due to sharp weapon. Then membrane lacerated with blood clot in left occipital region. Then left occipital area of brain is lacerated. Page 75, opinion of the doctor. In my opinion, the cause of death is due to shock
Sharp weapon.
following hemorrhage. My lord, injuries sustained is still for sharp weapon. In the conviction.
Ah.
Lordship is pleased to uphold the conviction.
There's no scope, otherwise you're not showing anything. There's no scope for going into any other. You're not arguing on whether it can
Lordship,
be.
the exception may not come here in this case.
Doesn't appear. There's nothing in the evidence to
Yes.
show that there was any sudden provocation
Yes.
or something. Very difficult. But yes, when you look at it on a broader perspective, it shows that there was friction in their married life and that she had run home. Probably there was something.
So wife was not examined, my lord. That's, Adhunika.
Yes, as a defense
Yeah.
witness. Because there must have been something, sure. you see, because of the friction in their marriage life, this has occurred. No other reason seems to be,
Yes.
forthcoming. But then, was that justification enough for killing a person?
My lord, my humble request to kindly be fixed on after vacation, my lord.
No,
please
no,
try
no,
again.
madam. Sorry.
My lord,
If you see the last order passed by us,
yes, my lord. I have seen, my
it
lord.
says here, adjournment has been made, adjournment on on 8 occasions.
Yes, my lord.
Adjournment on 6 occasions on the prayer of the appellant, while adjournments have been made on 2 dates due to non-appearance on behalf of the appellant. No further adjournment in this case will be allowed. So we cannot allow any further.
My lord, can we repeat it for Aadhaar? Can rest of the parties argue by this meter?
There's nothing else to, there are eyewitnesses, madam, there's nothing here. Heard, Miss
Read it.
P. Devi. P. Devi,
Yes.
learned counsel for the appellant. Also heard Miss B. Puyal, learned AP. This appeal has been filed against the impugned judgment dated 1/10/2016, passed by the Sessions Judge Golagat in Sessions Case number 171, 2005, by which the appellants, by which the two appellants namely Shri Khireshwar Tanti and Patal Karmakar, have been convicted under section 302/34 IPC and sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000 each, in default. Further, in default, simple imprisonment for 1 month. Acha, is this Patal Karmakar brother of,
Yes, brother-in-law. In relation, they are brother-in-law.
no, with Kireshwar Tanti,
A brother,
brother-in-law,
yes.
but another brother. Okay, right. The next para, the prosecution story in brief is that an FIR dated 1/8/2004 was submitted by the brother of the deceased, who was prosecution witness 1, bracket PW1, on 1/8/2005. So stop. The FIR stated that the appellant Hirveshwar Tanti and Patal Karmakar, along with one Shri Gajen Tanti, had chased the deceased person around 7:30 p.m. on 31/7/2005 and killed him by hitting him with dao, axe, hammer, etc. at the playground near his house. To stop. Thereafter, the accused persons had run away. To stop. Consequent to the FIR dated 1/8/2005, the Golaghat Police Station case number 376/05 under section 302/34 IPC was registered against the appellant and Shri Gajan Tanti, who is an absconder in the case. After investigation of the case was completed, the the investigating officer, bracket IO, who is PW number,
my lord, before it starts,
who is PW9, submitted the charge sheet.
The new, endorsed, SI, my lord.
Who was the initial SI?
Initial SI is with Raman Sangman,
PW?
PW9, but he is not examined. That now is my lord, Puneshwar Gagoi,
Oh,
he expired.
okay, whatever I said. No, cut PW. The IO submitted the charge sheet. On finding a prima facie case under section 302/34 against the appellant and Shri Rajan. It may be stated here that the appellant Kireshwar Tanti and the absconder Gajan Tanti are brothers, while the correct Gajan Tanti are brothers.
Not
No,
brother. So, Patal Karmakar and Kireswar and
are
his
brothers.
is brother.
The and
Brother.
Gajan Tanti, you don't know. It may be stated here that the appellant's Kireshwar Tanti, the appellant Kireshwar Tanti is the brother-in-law of the appellant Patal Karmakar. The deceased herein is also the brother-in-law of the appellant Kireshwar Tanti. In as much as Kireshwar's sister what's her name? Kireshwar's sister,
Aguni Tapi.
Aguni Tanti
Page 8.
was married to the deceased. Huh? Next paragraph. The learned trial court thereafter framed charge under section 302/34 IPC against the appellants and Shri Gajan Tanti, to which they pleaded not guilty and claimed to be tried. When did he abscond, this person, Gajan?
Before framing, sir, as per the.
Before
order-
framing charge?
Yes, but, page six, absconder by order dated 7/3, but that's a illegible manner, I can't read it. Page
Yes,
number
let's see the
6, my
record.
lord. It's in paper book.
Where did he abscond? Let us see the chart. It's the chart, the framing of charge. Okay. Give it to the. That's the same, but
Yes.
it is the person, what is the date? Was it before? Before or after?
That's what
That's what-
I don't.
In the charge, it will be written. In the charge, against his name, there's a date.
After search, as per judgment, after search, accused Gajendra Tanti has absconded. Case against
After charge.
after search. my
Okay.
lord. Yes.
Anyway, so to be pleaded not guilty and claimed to be tried. Correct? Full stop. Thereafter, the learned trial court examined 9 prosecution witnesses and 1 defense witness. The appellants, no, where is 313?
He was denied by
No, but where is it?
certificate case from 29 onward.
No, 313, madam, 313.
Yes, madam, 330 real, madam.
Where? Page?
Page 29
Page
in
29.
paper book, madam.
Yeah. Page 29, this is evidence, Miss Madam. This is not 313.
330 recording.
Okay, it is here.
Right.
Yes, 29. Arre, why is it not? Okay, examination of accused.
Yes, madam.
Okay.
330.
Only Kireshwar, what about the other person?
Other race on 33.
33 is Patel,
36 also, my lord, Kiresh sir.
836.
Yes.
What is this? How many times are they doing this?
What are the- 29.
One is on 2012, one is on 2016. Correct? What have I said? Statement of the accused of the appellant, Kireshwar Tanti, was taken under section 313. Not a statement, it's the examination of the appellant under section 313 CRPC was undertaken by the learned trial court on 2 occasions, that is on 18/7/2012 and 14/8/2016. Not 14/8, sorry,
Four-
sorry,
four-eight,
sorry,
madam.
not 14/8,
48.
4/8/2016. Similarly, examination of the appellant Patal Karmarka was under section 313 CRPC was done on 18/7/2012 and again on 4/8/2016. Why?
Sometimes they do, my lord. Earlier also I have found, lordship, because sometimes they don't
Stop.
put
Next.
relevant questions.
The learned trial court thereafter came to a finding that the appellants herein who are guilty of committing the murder of the deceased in furtherance of the common intention. Furtherance of their common intention to kill the deceased. As such, some of the appellants were convicted under section 304 like 34, I think. And sentence as stated in the foregoing paragraph. Are you supposed to- So the 9 is the subsequent item. Which are you with? Who is the original IO?
Roman Sangmai,
Ah, Roman
Sangmai.
Sangmai.
Yes.
Where do you get the name?
Died is my lord, I will expire as per the order dated London 26/6/2030. 20, page number 27.
Page 27.
Yes. Bottom part.
Should mention at page 88. With your charge sheet. Yes, I Roman Changmai Bolagat is expired on 17/1/2007 as per report
Page 20.
88.
27.
Page 88, nothing is there stated. Where is it stated?
Page 88, my lord.
Yes,
88.
88 I've got. It says ASI Roman Changmai got expired on
71.
71.
21/2007 as per report.
But my lord, in 27 is a different date, my lord.
I will read it. I will.
Bottom part, sir.
No, what expired? No. As per the order of my late predecessor dated.
26. Yes,
So
sir.
that is nothing.
Yeah, or,
No, anyway, when was the charge sheet submitted?
uh, okay.
21/9/05, page 86.
21/9/05. He died in 2001. When did the incident occur?
Incident 180, incident 31/7/05.
Yes, sir.
31/7/05.
7/7/05.
And Sangmai died on 2007. So that sheet, the person who submitted the charge sheet died. After submitting where charge sheet submitted on September 2005.
Yes.
So he died in 2007 after submitting charge sheet. Okay, so where are we? Paragraph. Next paragraph. Mrs. P. Devi. Mrs. or Miss? Mrs. Mrs. P. Devi. The learned counsel for the appellant. Submits that. What do you submit? What is your point?
Point is, my lord, there is certain provocation part is there, my lord.
Submits that the incident
The quarrel between wife.
that the incident appears to have occurred due to a quarrel that due to the quarrel that had ensued between the
It is
deceased and
appellant
his wife, comma, who is the sister of the appellant number one. That's all. Any other
There is
question?
no independent witness also, my lord. Yeah. And
He submits that there was no independent witness, independent eyewitness
Yes.
to prove the assault on the deceased by the appellant. Comma, in as much as PW1 is the brother
yes, my lord.
of the deceased, while PW4 is also, no, PW1 and 4 are the brothers of the deceased.
Brother, my
Seven also.
Seven. Yes, my lord. The PW7 also brother. Elder brother.
As PW1, 4 and 7 are the brothers of the deceased. That's all. Anything else? They are out on bail over these persons.
Yes, he is a 30 on bail, my lord.
And
Photos of the
Gajan?
Huh?
Gajan is absconding. And this other person,
other person is in bail.
Patel Karmakar, is in jail.
His bail is was rejected, my lord. Also, where is my lord, this PW1 submit that Kiresor with arm with rod, axe, hammer, and dao, my lord. But the dao and the rod was not seized. Only material exhibit is, my lord, on hammer and axe, my lord.
Hammer or
Yes, my lord, hammer and axe, sorry.
hammer and axe.
Yes. But as per PW1 deposition is the Kiresor use with rod. And but the IO, when examined by the IO, this part is not clear, my lord. The re-examination on the point of this, my proceeding investigation officer, the PW Pipulgoda statement. In his statement, he did not tell me in this manner when Professor Tati dealt a blow on my arm, I snatched the rod from him and dealt 2 blows to him. And second part, my lord, this Kirasari Bora, who is the mother of the deceased, is also that Bora did not tell the IO that she had seen Kirasa standing there and armed with a rod, nor did he state that accused Kirasa told that he would turn Diganta
Sana,
into
where are
dead
we?
body.
The manner in which these things happen. He was a drunkard. It's always fight. Kill naturally. But it appears that because of the harassment caused to the wife, of the brothers have killed.
But he cannot, it should be grave and sudden provocation on the date of occurrence. And
That is the that is the problem, madam. We're trying to find out something in your favor.
Just a minor kindly pick another date. That can,
No, how will that help? You running away and not adjourning the case for so many years. Doesn't help anyone.
my lord,
No, madam, this 2017 matter. We cannot do it. We cannot allow.
Yes.
You try to, you
Yes.
find, you show us something we can,
yes, my
which
lord,
we can legally take care of, that's a different thing.
Yes.
As per the law. But we cannot allow you to run away and adjourn the matter. It's not that we don't have sympathy. Unless you show us how to channel that sympathy in your favor. As per the law, it's very difficult for us. Very difficult. That is the problem. You see, when you do something, when you do some act, you do some act, it should be proportionate. No? Whatever faults he had, there is nothing to show that he used to beat up his wife or something. It was quarreling. Maybe he used to harass, maybe we do not know. There's no evidence that she used to be beaten up and and that suddenly they got angry and then they rushed or something like that.
therefore the wife was not examined, my lord. It's
Not
only
only
that
that.
he was
Oh,
examined.
Lordship,
that
one
it's clear.
point, maybe it goes in their favor. Page 12. My son, that's page 12, cross-examination, third line. My son used to consume liquor every now and
I know. That
Go to the
that is
page
why we
one.
are saying this. That
Either
is why we are saying this. You see, it shows that they did not have a very
cordial.
smooth life. When he was probably sober, everything will be hunky dory. But once he starts drinking, then he'll be everyone's pest. It happened. But then they did not develop on this story. They did not develop. You see, there's another thing I saw. He was on fire. Nothing. How? Fire where? Cooking, not cooking, what happened? Inside the house, outside the house, where? Whose house? So those, how can we improve a story? Though we, on a belief that, something was not well in the marriage. Very difficult. We are trying to see if some plausible excuse can be there. But very difficult to find, madam.
One line.
Yes,
I should not submit that since your lordship is trying to give some benefit. Today he again had a quarrel with his wife in the afternoon.
they were in.
Then then his wife left for a paternal home which was nearby.
That is nothing,
Yes,
no,
later he again
there,
went to the house of the in-laws and wanted to quarrel with them. Pacified and brought her back, but it was not a sudden lordship, yes.
how does it matter? You have a quarrel.
Yes.
If it was something to be beaten up black and blue, that's again a different thing. Quarrel to happen. It depends upon the family. Some women might quarrel and might remain put in the house. Some will maybe run to her parents' house. You know, some might in fact beat up the husband. The other way around it can be also. If the lady is a big one, big solid one, and
Yes.
I saw one WhatsApp clip sometime back. The wife beating up the husband. So I don't know, it depends, but then would this justify killing a person? I doubt. It has to be proportionate. Them quarreling and being killed for that, not proportionate. Very difficult, madam. Unfortunately, we have got to pass an order as we deem proper in the facts and circumstances of the evidence that you. As per the evidence, not in the fact, as per the evidence. Okay, right. Where are we? Huh? Ah, good stuff. As they are interested witnesses, their evidence would have to be taken with a pinch of salt. He accordingly submits that the case that the charge against the appellant be altered to that of section 304 part 1, part 1 IPC. Next, Ms. B. Buyan, the learned APP, submits that there is no contradiction in the evidence given by the witnesses vis-a-vis the statements given under section 164 CRPC and 151 CRPC. Correct?
I will encounter there.
She also submits that PW 1, 4, and 7 being eyewitnesses to the incident and the same having withstood the cross-examination, the case of the prosecution has been proved beyond all reasonable doubt. Anything else?
PW1 is also an injured eyewitness.
Further, PW1, who is the brother of the deceased, is also an injured eyewitness. So she also submits that the evidence of PW4, PW,
Whom I lay extrajudicial confession before.
PW2, who is the mother of the deceased, is to the effect that the deceased had told the mother that he had been assaulted by the offender. As such, due to the extrajudicial confession made, there was which corroborated the evidence of the eyewitness. There was no ground. There is no ground to interfere with the impugned judgment and all. Impugned judgment. We have heard the learned counsels for the party. The evidence of PW 1, 4, and 7, who are the brothers of the deceased, show that they had seen the appellant and Gajen Tanti assaulting the deceased with an axe, hammer, rod, dowel, etc. PW1 in his evidence has stated that when he went to the place of occurrence, on hearing that his brother was assaulted, when he heard that the deceased was being assaulted, he found the appellant and Gajen Tanti. Appellant number 1 was armed with a rod, an axe, hammer, rod, and a dowel were lying near his deceased, his elder brother. On seeing him, appellant number 2 and Gajen Tanti ran away. However, appellant number 1 hit him with a rod on his arm, saying that he would kill him. PW1 thereafter snatched the rod from appellant number 1 and hit him twice, due to which appellant number 1 fell to the ground. While calling his family members, appellant number 1 fled from the place. PW1 stated that he saw the cut injury caused with an axe in his elder brother's head and the piercing injuries caused with the rod in the abdomen and cheek of the deceased. The police seized the dowel, axe, and rod, which was exhibited as material exhibit 1. The next para, the cross-examination of PW1 showed that is to the effect that the deceased used to come home in a drunken state. No. Cut that, no need. The evidence of PW4, who is another brother of the deceased, is that on hearing the hue and cry and the sound of beating near their house, PW4 went out of the house, where he found the appellants and Gajen Tanti assaulting the deceased with axe, hammer, and a rod. The appellant number 1 was armed with a rod. The appellant number 1, Kireshwar Tanti, was armed with a rod, while Patel and Gajen were armed with an axe and hammer respectively. Although the appellant number 1 chased PW4, the blow did not land. And tried to hit him with the rod. The rod did not hit him as he had moved aside. Thereafter, appellant number 1 dealt a blow to PW1 with the rod, whereupon PW1 hit the appellant number 1 twice with a fence post. They also stated that PW4 also stated that the deceased died on the spot. Subpara. In his cross-examination, PW4 stated that the deceased had married the appellant number one's younger sister. And that the members of the family had not given consent to their marriage. The evidence of PW7, who is another brother of the deceased, is that on hearing an alarm outside his house, he saw appellant number one and two assaulting the deceased in the playground. After the assault on his brother, the appellant went to the police station. He also stated that he put his signature on the seizure list regarding the seizure of one axe and a hammer from the place of occurrence. Next one. The evidence of PW2, who is the mother of the deceased, is to the effect that while she was cooking rice at around 6 p.m., she heard a hue and cry. On going out, and with the help of a lamp, she found the deceased lying in the field. The appellant number one was standing a little away. The appellant number one and two were there. And appellant number one told her that he had turned the deceased into a dead body. Appellant number one then tried to assault PW1 on his head with a rod. He saw PW4 saw PW2 saw PW1 hold the rod, and on seeing the dead body of the deceased, PW2 became unconscious. Subpara. In his first examination, PW2 stated that the deceased had eloped with the younger sister of the appellant number one, Kireshwar, and lived as husband and wife. So since the appellant number one belonged to a different community, they were not on visiting terms. Further, the deceased used to consume liquor every now and then. And the married couple fell out quite often. So stop. Even on the day of occurrence, the couple had a quarrel, whereupon the wife of the deceased left for her maternal home. Next para. The evidence of PW3, who was the medical and health officer once at KK Civil Hospital, Golaghat, is to the effect that there were deep cuts over the left occipital region and fractures. There were cut wounds on the cheek, and the membranes were lacerated. The brain was also lacerated in the left occipital area, and the injuries were ante-mortem in nature. Ante-mortem in nature. It further stated that the injuries were caused by a sharp. In his opinion, PW3 stated that the cause of death was due to shock following hemorrhage as a result of the injuries sustained by the deceased. The particulars of the injuries sustained by the deceased as given by PW3 in its evidence, is as follows. Page 14, okay, from 1 to 8. Okay. It takes this, that is page 14 and 15. Next para. The evidence of PW 5, 6, and 8 are only hearsay evidence. Correct? 5, 6, and 8 are hearsay evidence. Next para. The evidence of PW9, who is the second investigating officer, as the first investigating officer had expired on 17/1/2007. That is after. No, don't say that, David. Just say like this. Cut that entire paragraph. You just say. The first investigating officer, Roman Sangmai, Sangmai, could not be recorded by the learned trial court, as he had expired on 17/1/2007. That is after submitting the charge sheet on 21/9/2005. However, the evidence of PW9, who is the who was the OC of Golaghat police station on 1/8/2005 is to the following effect. On 1/8/2005, he received the FIR submitted by PW1 and registered Golaghat PS case number 376/2005 under section 302/34 IPC. ASI Ramesh Changmai, CHANGMAI, was endorsed to investigate the case. The FIR was exhibited. No, before that, right? The ASI Ramesh Changmai investigated the case while he, bracket PW9, supervised the investigation. The investigate PIO sees a hammer fitted to a bamboo handle and no, comma X and an no, sees the hammer and an axe. PW9 also stated that Ramesh Changmai submitted the charge sheet. Under section 302-34. Next para. The evidence of DW1 who is the owner of the car driven by the appellant number 2, bracket Patal Karmakar, comma, is to the effect that appellant number 2 drove his vehicle from 2001 to 2005. Following the day of occurrence, the wife of the appellant number 2 came to his house crying and told him that the appellant number 2 had been taken by the police. Next part. The examination of the appellant under section 313 CRPC is basically to the effect that the evidence adduced against them was false. Was to the effect that they had nothing to say. So that's a false statement. False statement. That's it. They have got nothing to say. And that they were false statements. That's a false statement. False statement. False statement. Okay, just say that. Whatever that. Is done on no 313 CRPC done on 18/7/2012 is basically to the effect that they had nothing to say with regard to the evidence adduced against them. Full stop. However, in the subsequent examination of the appellant under section 313 CRPC taken 4 years later, that is on 4/8/2016, is to the effect that the evidence used against them were all false statements. Next paragraph. Yes, sir. On perusing the evidence given by PW 1, 4, and 7, we find that the evidence given by them in the examination in chief has not been shaken by the defense during cross-examination. Further, just because they are brothers of the deceased, comma, the evidence of PW 1, 4, and 7 cannot be discarded, especially when there is no whisper of any enmity or reason for PW 1, 4, and 7 to give any false evidence. In the case of state of UP versus Samandar, AIR 1972, ST 67, the Supreme Court has held that relationship of the prosecution witnesses to the deceased by itself is not sufficient for disbelieving their testimony, unless motive is alleged and proved against them to spare the real feeling. It is well known that close relatives of a murdered person are most reluctant to spare the real assailant and falsely involve another person in place of the assailant. Especially where there is no cogent evidence on record to show that there exists any animus between the accused person and the deceased, or the prosecution witness, who are relatives of the deceased. Anything else?
Regarding general exception part, learned trial court is discussed about it, page 64. There are
64.
Why this case will not fall under the general exception?
On perusing the provisions of section 300 and the exceptions therein, there is nothing to show that there was any sudden or grave provocation on the part of the deceased to have given reason for the attack made on the deceased by the appellant with the kind of weapon used by them. So further, the injuries sustained on the deceased is on the vital parts of the body. And as such, there is nothing to show that the exceptions to section 300 can be applied to the fact of the
Deceased was unarmed, they were armed with weapon.
So
So
further,
there's intention to kill.
further, the deceased was unarmed and while the attackers, who were 3 in number, were apparently armed to the teeth. If you have the reasons stated above, we do not find any reason to interfere with the impugned judgment passed by the lower Senate panel. The appeal is accordingly dismissed. The bail granted to the learned to the appellant number 1. 5 minutes up. Trial court. The bail granted to the appellant number 1, that is Kireshwar Shanti. By order dated 10/2/2017. Passed in IA Criminal 53/2017. In Criminal Appeal 1 of 2017. Is cancelled. Is it the right one?
Bail bond was with the
Is cancelled. The bail bond executed is forfeited. And is directed to surrender before the
before the,
which police station,
no, it will be before the court, Your Lord.
before the court of the, before the learned trial court. That is.
Has been to
before the-
Huh? District Session Judge Golaghat.
Before the,
Session Judge Golaghat.
before the district session judge Golaghat. Immediate.
Lordship, instead of surrendering, can he be taken into custody, madam?
To serve out the remainder of the sentence. In the meantime, the respondent police are also directed. Take him into custody,
Jail authority.
take him into custody and and produce him before the Senate panel.
Jail
No,
authority immediately.
he surrender also in the meantime, police can also. That's how they'll found the necessary order. We'll just push it. Send back the LCR. What to do, madam? We tried. There's nothing. Here, there's something you could have developed a case, but then there's nothing for us to move that direction. So, Merry Christmas, Happy New Year. See you,
Your Lordship, my,
see you in the new year.
yes, 2024.
Yes. I don't think you'll be having TV, I think, this year. I don't.
Yes,
At least
yes,
this bench, I don't think.
I just- Tomorrow we don't have people.
Yes, anyway, because if you have any urgent matters, I think you can go to DB2.